political.
Welcome to the City Planning Review Session, and Madam Secretary, you may begin.
Thank you, Mr. Chairman. Good afternoon, everyone. This is the City Planning Commission Review Session, and a quorum is present. Today is Monday, August 8th, 2016. The first item on the agenda is a Queens pre-hearing action with respect to a proposed notice of intent to acquire office space for the Queens DA. Now, presenter is Brandon Pilar from the Queens office.
Good afternoon, Mr. Chairman. Good afternoon, Commissioners. I'd like to begin today's review session in Central Queens in one of the borough's civic hubs. And this is the setting where DCAS, acting on the behalf of the Queens District Attorney's Office, seeks to acquire 40,000 square feet of office space to help alleviate long-standing overcrowding issues with the District Attorney's Office, and also to allow for the consolidation of several of its trial units, its crime victims advocate units, and its Office of Immigrant Affairs to a location located directly across the street from the Queens County Criminal Court Complex. Now, as I mentioned, the project site is situated in one of Queens' civic hubs. It is situated along Queens Boulevard, which is a major arterial that connects Long Island City to the west and Jamaica to the east. The civic uses are really located to the north of Queens Boulevard. We have here the Queens County Criminal Court Complex, as well as Queensborough Hall, which is home to the Queens Office of the Department of City Planning. As I mentioned, the civic uses are more to the north of Queens Boulevard. To the south, you really have a mix of medium and high-rise residential buildings with ground floor retail uses located along Queens Boulevard, before the scale of buildings steps down pretty quickly as you move to the south of the project area across Queens Gardens Road into a low-density residential enclave. The site has good proximity to transit. It is within a quarter mile of the E&F subway lines, and has good access to several highways in the area, including the Van Wyck Expressway, the Union Turnpike, and Grand Central Parkway. Now, as I mentioned, the proposed intent to acquire office space would help alleviate serious inadequate office space issues that the Queens District Attorney's Office has been dealing with. Its original office is located in the Queens County Criminal Court Complex. It was built in the 1950s. But the current staff of the Queens DA is over 8 times the size it was back in 1950. Queens DA has utilized several methods to help provide space, including double, tripling, and even quadrupling office assignments, and also locating staff in other locations, including Queensborough Hall, and at a privately owned site at 80-02 Kew Gardens Road. But despite those efforts, there are still overcrowding issues, and its current staff of approximately 800 staff members is working in space of about 132,000 square feet. So the project site, which is located, as I mentioned, right across the street to the south of the Queens Criminal Court Complex, outlined in red there, is a 40,000 square foot office facility that is privately owned. Queens District Attorney, acting with DCAS, would seek to acquire this through a 20-year lease with a 10-year option to renew. As I mentioned, this would allow for the consolidation of several trial units with the Queens District Attorney's Office, as well as the Crime Victims Advocate Unit and the Office of Immigrant Affairs. Now, it is expected to be open to the public from 8 a.m. till 6 p.m. Monday through Friday, but due to the nature of criminal prosecution, 24-hour access would be required for all employees, and the Office of Immigrant Affairs would expect to have outreach events beyond 6 p.m. and on the weekends as well. As part of the lease agreement, the owner or the landlord has agreed to provide 30 parking spaces, which are located in a subgrade parking garage as part of this larger building complex here. And the QDA, or Queens District Attorney's Office, plans to reserve those spaces for attorney parking. Now, as mentioned, that this is on for pre-hearing. We expect both representatives from DCAS and the Queens District Attorney's Office to come speak at this hearing. This application was also sent to Queens Community Board 9. I do not expect anybody from Queens Community Board 9 to come to the hearing on Wednesday. Thank you.
Thank you, Brendan. Questions? Mr. Dweck.
A question about the funding. The city picks up the tab, or this is through the state?
would be through the city.
Just the courts.
Just the court, yeah.
The courts of the state, but the DAs of the city. Okay.
Correct. And I would only add that this location has housed several public-facing agencies. Most recently, the Board of Elections had used this office space for 13 years. And as you can see, it's going through some much-needed upgrades after those 13 years. And prior to that, the Department of Buildings actually used this office space. So it has a long-standing history of housing public agencies.
Thank you.
Ms. Heffron?
Well, then that begs the question, are there any private tenants in that building, or would that be a
No,
possibility
entire
for the
space
city
is
to acquire?
available and would be occupied by the Queens DA's office.
So is this one that the city is considering owning?
That would be a good question for DCAS, but right now, the arrangement that the city has worked out with the current landlord has been through leases.
Thank you.
Ms. Delausse?
Can you just repeat the number? Did you say 800 staff, 140,000 square feet total?
40,000 square feet.
No,
And-
no,
I'm
but
sorry.
I mean, total for the agency.
Sure. Office-wide, it's 800 employees, and they have 132,000 square feet of office space.
So I'm assuming they are continuing to look for additional space?
Yes. Yes, but there have yet to be any real concrete long-term solutions to address this overcrowding. So when this space became available, they were obviously
It
very excited.
sounds kind of acute.
Very acute. We've seen situations exactly the reverse, where there have been 4 employees and 140,000 feet. So,
Check the Citibank building.
I was here last week.
any other questions for Brendan? Thank you, Brendan.
Commissioners, item number 2 has been withdrawn. That's the 102-05 Ditmars Boulevard parking garage. Moving on to item number
Face it,
3.
little slog.
We have a Bronx pre-hearing application or project with respect to several land use actions, proposed zoning map, zoning text, and city map amendments, UDAP designation, project approval and disposition of city-owned property, special permits, a modification to a previously approved special permit to facilitate the Lambert Houses redevelopment. And our presenter is Oscar Oliver Didier from the Bronx office.
Good afternoon. Before I begin, I just wanted to quickly clarify. We saw this back in April. There's a significant amount of slides. I kept them just in case in the Q&A we want to go back to something, but I'm going to skim through them quite quickly. But then again, if you have any questions, I'll clarify. So Lambert Houses redevelopment is a 12-acre site with 1,665 affordable housing units over 4 parcels. Just to give a basic overview, the applicants are both Department of Housing Preservation and Development and Phipps Houses. It's in the West Farms neighborhood. This is Community District 6 in the Bronx, Council District 15. And the current zoning is an R71 and also an R71 with a C14 overlay. It's important to note that the project is currently part of the Bronx Park South large-scale plan, which was approved back in 1965. And as part of this proposed project, a new large-scale residential development will be created, and the existing large-scale plan would be modified. So there would be a subdivision. Important also to note that the new large-scale plan will occur over a sequencing plan that will span approximately 13 years. So just to understand more or less what lies in the surrounding areas, the yellow outline points out the current large-scale plan boundary. You can see in the sort of outskirts of the project important transportation corridors such as the Bronx River Parkway, Southern Boulevard, and the Cross Bronx Expressway. Important public space amenities such as the Bronx Park Zoo up in the north. Use this. And then over here in the south west is Crotona Park. In terms of transportation, the 25 line runs across the site, placing the West Farm station of the 25 line actually inside of the large-scale boundary. And just to give a basic overview in terms of what lies in the area in terms of zoning, here again you see the R71 zoning. You see a light manufacturing area over here, and some commercial overlays over here at East Tremont, and some over here on East 180th Street. And then this is looking at the current Lambert Houses project for the north. You can sort of see River Park here, and then the Bronx River sort of running south of that. You see how the parcels owned by Phipps have these sort of light peach or orange colored 6 to 8 story buildings, but you also see that as part of the current large scale, you have multiple owners up down here in the south, including a few NYCHA towers. So this is the, again, the project area and the existing large scale boundary. And just for clarification, these red outline areas are actually the parcels owned by the applicant, again, Phipps. And then this is what subsequently would be what would sort of at the end of the sequencing plan have, or would be the actual new large-scale plan. So this would be, again, the modified existing large-scale plan and the new large-scale over here in the north. Very basic overview of what's in the project area right now. You see that most of the parcels have a significant amount of housing units, and parcel 10, different from the other ones, has approximately 40,000 square feet of retail space, some parking, and no housing as of now. And then the rest of the large scale is also quite similar. There are multiple owners, as I said earlier, some affordable housing units, again, the NYCHA towers, and parcel 9 over here, which is currently holds some retail space in a closed parking garage. Again, we this certified a few weeks after we saw this project, which is being proposed, 1932 Bryant Avenue, which is proposing close to 300 affordable housing units, just so you understand more or less the context of what's happening in the area. Again, sort of like another view that you can sort of see what the project looks like right now. It's important to note that there are a few DMAP streets that were put in place when the large scale originally was made. It's also important to note that wayfinding is a bit difficult in the area. There's too many entrances. We keep hearing that there's sort of like a lack of ownership, or a sense of ownership that's lacking in residents. And in significant sort of amounts, you have underutilized courtyards throughout the projects. But again, it's important to note that there is an existing community here, and as part of the project, again, 13-year sequencing plan, there's an important sort of relocation process where all residents would be given the option to relocate inside the new project. So it's a very complicated sequencing plan where you sort of see when residents get relocated, when buildings get rebuilt, when they get demolished. And again, this is over a span of 13 years. And then this is the subsequent sort of build out or master plan. And again, just so you have a better understanding of what's being proposed, you sort of see how buildings sort of align to the street line. There's a better sense of sort of like clarity in terms of where building entrances are, and of course, what sort of gets sort of like the attention of one's eye is sort of like the importance of these sort of courtyards that, again, are going to be or have a better sense of ownership, and residents can sort of use them frequently. And this is a diagram that sort of helps explain what basically were the urban design decisions behind the project. You sort of see where height and some of the commercial overlays are going to be put in place along Boston Road. This would be sort of like the pedestrian access from the 2-5 line up through that corridor and then into actually the Bronx Zoo. And then you sort of see where height is being concentrated on wide streets. You see the courtyards again, how the DMAP streets are turned then into sort of private roads that are both pedestrian and car accessed. And then you also have, most importantly, some view corridors that are being proposed throughout the development where you sort of can see and understand and have sort of like that visual relationship to the Bronx River as a sort of like a public space amenity. This is more or less what the final outcome of the massings would look like. And just so you know, a basic overview of the proposed redevelopment, again, an R8 with a C14 overlay in some portions of the development. It's 1,665 units. It's currently 731. There's 61,000 square feet of retail being proposed, 86,000 a community facility, and then 110 accessory parking spaces. And then, again, sort of like a basic overview of where those 1,665 units would be located across the site. And an overview of the actions, which we sort of briefly explained in the beginning, modification of the previously approved large-scale residential development, rezoning in certain portions of the project from R7-1 to R8, with some commercial overlays of a C14, UDEP and disposition of a city-owned parcel, a city map change, again, to have a map an MIH area, text amendments, and then special permits and authorizations. So this, again, we could always go back to this, but here it's in more detail, but I feel that the slides can speak better. Again, the modification of the approved large scale plan, the new boundaries. Let's slide again so we can sort of understand. The current zoning, the proposed zoning, where you sort of see how the R8 is being concentrated on those wide streets, and then the commercial overlay sort of continues up until Boston Road across to the Bronx Park, the Bronx Zoo. And then this is actually a zoning map amendment of the rezoning, the zoning change map. Very basic sort of understanding of how the portions being rezoned as R8 is basically permitting more with the transfer of open space requirements and of FAR in the R7 areas that remain in the center, sort of help give and provide more affordable housing and also provide obviously the courtyards. The city map change, this is the portion I was telling you about. It's a small portion that's owned currently by HPD. It was never transferred to DOT. The original purposes was to create a sort of like a right turn there. It was never even utilized for those purposes, and instead it's sort of used as a public space right now, and it would remain as a sort of a public space when you come out of the 2-5 line there. Also, very important, a text amendment to sort of treat the sort of like a lot line abutting the park and to permit legal windows there. Again, this is sort of to permit, it's for security reasons, to have sort of like an eyes on that park, and also for like building efficiency to make sure that those units are maximized. It's important to note that currently the Lambert Houses development, the building that's currently there, also has legal windows facing the park. The MIH map, we talked about this last time. It ranges from 60 to 80% of AMI, and it's going to sort of keep the 728 units of section rental assistance that currently lie in the Lambert Houses project. And then zoning special permits, again, since the large scale is being subdivided, you would create some special permits that would be required now and some authorizations along the interior of the large scale. Landscape guidelines, which have, again, very importantly, we want to assure the quality and active use of this area. So it's being, landscape guidelines are being placed as part of a restrictive declaration that has to come back for assured certification. And a basic sort of rendering of how some of these landscape guidelines will sort of feed into sort of like the sense of ownership and active use of these courtyards. And basically wrapping up environmental review, HPD as the lead agency released a notice of completion for the DIS on 4/22/16. Identifies potential significant adverse impacts related to community facilities. These are mostly for intermediate schools, shadows, and transportation, both in the case of vehicular and pedestrian circulation. The public hearing for this DIS, again, will be this Wednesday. And the Community Board 6 held a public hearing on June 22nd, and the recommendation was to approve the project with no modifications or conditions. And the Bronx Borough President held a public hearing on June 26th. His recommendation as well was to approve the project, and no modifications or conditions were stated. So just concluding, it's important to sort of state that the proposed actions will result in the construction of the Lambert Houses redevelopment. It will provide an opportunity for new affordable housing units for existing residents and create 1,000 additional affordable housing for the community, new retail, and community facility spaces as well. All as part of a better site plan that matches surrounding character of the community. Thanks.
Thank you, Oscar. The community board had a significant number of people who voted in opposition, even though the board as a whole approved it with no conditions. What were the concerns?
Some of the concerns were traffic that would be created both during construction and after sort of like the project is finalized. And it's important to note that DOT is sort of putting in place some, which is typical of these kind of projects, widening of sidewalks, making sure the crosswalks make sense, all for that sort of pedestrian safety. Other things had to do with affordability and how deep that would go.
Mr. Knuckles, and then, is that Mr. Cirillo? No, Mr. Knuckles.
Thank you.
And then Ms. Efron.
Oscar, do you know, well, first of all, with an additional 1,000 units ultimately to be developed here, what is the threshold for SCA to determine whether a new school is warranted?
Right, so I forgot to actually state that, but on parcel 10, which is this one right here, I'm sorry, this one, SCA would have the option to sort of build a school there. They would have to submit a letter of intent. If for any reason SCA decides not to build that school, an additional 55 units of affordable housing would be created. But again, it's important to know that that impact would be felt, that school's impact would be felt at the end of the, sort of like the phasing of the 2029 last building phase of the development.
So they won't commit until
They have,
then?
as of yet, they have not sent a letter of intent, but we are following up before the hearing to make sure that where they stand with that.
Well, my assumption is that this, the reason that SEA can't commit is because they don't know, it's so far in the future that they don't know the projections or the projections at this point in terms of number of eligible school children is speculative. So I assume they can't really decide until it gets a little closer. Is that?
And it's important to know that that particular parcel is one of the last phases in the sort of like the phasing sequence. So it's not like, well, that's one of the first phase, we didn't need it then, we don't need it now. That's sort of like on purpose to make sure that that's at the very end of the sequencing plan to make sure that that need is sort of mitigated.
Ms. Efron.
Thank you. I hope the developer will be able to speak to three different things. I had two, but I'm going to add one from the vice chair's question, which is, will that parcel be held for a school? But also, will people be moved twice, or is the intention to relocate people into a more permanent residence, or is it to move them back? And then the third question is, particularly on this slide, which I know is for other purposes, but it looks as if there's no barrier between the park, even though there's no elevation shown, and the properties themselves, and yet one of the other renderings showed fences. So I think it would be useful to understand how permeable the open space is to the public, or how secure it is, and there are merits to both of those. But I would like a better understanding of what the how the landscaping works with the streetscape and the park.
Okay, so to the last question, most of the detailed construction document or plans are mostly for building 3A, which is the first phase of the project. But if I were to judge, this is probably best to ask the applicant, but if I were to judge, currently the Lambert Houses building that lies here has a fence. It has high levels of transparency towards the park, which is a good thing. So I'm judging that it's going to be something similar to that. As for the second question, which again was, I'm sorry.
Whether people relocated
Right,
are relocated once or twice.
So I would, for the first phases of the sequencing plan, they would most likely have the option to move again to the sort of like the new buildings. It's important to know that for building 3A, though that has already, the sequencing plan has already started, so that building is currently empty. They have been sort of relocated to the existing BIP houses development. Again, this would be a question better suited to for the applicant to answer, but I'm guessing that they would have the option to also sort of say, I actually want to go to like a new unit. In the end, at the very end, they're gonna have to. I guess it depends when, because the whole project is being, again, demolished and rebuilt. I just want to make sure to answer the question in terms of like, when do they have that option? And if they would have to move twice? Yes, they would, especially in that initial stage of the sequencing plan. Inevitably, they're moving into existing Lambert houses.
Okay, so just having an understanding of, is that every other year, or is that over, it's 10 years in one location and 3 in another? It would just be useful to know, and also what the rights are of those tenants for the types of units. In particular, I'm thinking of elderly residents.
Good afternoon. Just to clarify, outside of this first building, which of course is a new building is not built, the sequencing plan, its intention is to allow for residents to move as new buildings are built into those new buildings so that they will only have to move once.
Ms. Ortiz?
Hi, good morning. Some questions about the retail in the parcel 10A, is that it? No, it's labeled 10A. So I'm noticing there seems to be significant open space or either underneath the elevated or immediately adjacent to the elevated. You know, and you can see it there. I'm not sure what's happening under there, and it's fairly significant. It's front-facing. It's where most of your residents would end up, you know, as they walk towards their retail. And I wondered if you could speak to that, because I couldn't really find much in here.
Under the elevated itself?
Yeah, I mean, what's happening there? What are the conditions of that environment? Is that part of any of the improvements? You know, because that can be a fairly foreboding experience. You know, if that's being considered as part of the improvements that need to happen, or what is in fact being considered there.
I'm not sure which parcel you mean, but I think the intent of the plan was to shift a lot of the bulk
That's right.
and commercial overlays to that space along the elevated train that would allow for kind of a more active.
So you just pointed at it with your red
Right.
marker. What is happening there?
I think it's currently under the elevated itself. So I think that there's open space there right
Today.
now.
Right. There's a plaza there today.
Right.
And I'm not sure if the intent is to maintain that as it is today. It's not functioning that well. We can find out more and clarify exactly what's going to happen in front of that area.
Yeah, I mean, there's so much thought given to so many of the public spaces, and that in fact will end up being an important public space, but we really haven't addressed what will happen there.
We can make sure that that's clear on Wednesday.
Okay, and one other quick follow-up.
Sure.
Also, you know, you noted that 40% of the retail is going to be at that location. 40,000 square feet of 60,000 square feet will be at that location. Could you speak to the balance of retail, and is the intent to try to distribute it, you know, up and down Boston Road, you know, equally, or you're trying to concentrate it? And I presume it's going to be convenience-oriented retail. What is the intent?
Right, so again, this sort of helps in sort of letting us know where exactly that commercial overlay lies. So again, it will be occurring across Boston Road, and of course, there will be a significant amount of retail space also here, because, I mean, it was sort of, the applicant thought that, again, closer to the 2-5 line, it currently sort of has a feeling of being sort of like a central retail space. It would just sort of solidify that even more, but it's also important to sort of like create that commercial corridor up through.
But 20,000 square feet of retail is not much. And so my question is, you know, is the developer hoping, and this could be a question for the developer, to distribute it, you know, piecemeal as you go up Boston Road? Or is there another small retail concentration that will occur? What's the plan for merchandising that? So if he can answer that question.
They could probably answer that.
Okay, thank you.
Ms. Deluz?
Hi, a couple questions, and mostly just to put them out there for the development team on Wednesday. So given that this is a 13-year phasing plan, it would just be helpful to know what the status of the first phase of financing is and how they plan to, what are the plans for future financing and how that may impact the timing if it's not secured when they think it might be secured. It'd be good to learn from the development team how current residents have been involved in informing the plan thus far. And I'm just wondering if I didn't see it, but were there in either public hearing, did the issue of some kind of community advisory group to oversee and have input into the construction impacts and things like that? It's a pretty large project over many, many years. It's interesting. I'm just wondering if that came up or if we should expect to hear that recommendation. And then last but not least, so the Fordham Bedford, the Catholic and the Nitro property, so they'll remain in the original large scale, if you will. Are there, and if there's anything we should know about future discussions about that and how this project has informed those, it would be helpful. Just, I would like to learn that.
Okay. I would add that it's worth noting that it's beneficial that Phipps is the current administrator of the development today, and they will be in the future, and they do have a good and active relationship with their current residents, and I think that's been a big part of the process.
Commissioner Levin.
Just following up on some of Commissioner Efron's questions, I have a question about how the landscape guidelines were developed. What relation do they bear? I mean, I guess the guidelines that we're all familiar with are the POP standards for publicly accessible private open space. Do these relate to those in any respect? How were those developed?
So they are based on existing sort of guidelines that feed into these sort of open spaces that somehow lead to privately owned areas for residents. But they're mostly dealing both with how there's a significant amount of hardscape and softscape, that there are amenities that sort of lead to the active use of these spaces, that there's higher levels of transparency, different ways of entering the area just to make sure you have foot traffic. So these were mostly developed along those lines.
Mostly developed along the POPs lines, or?
Based on those, but then sort of very specifically tailored to what a courtyard actually is, which is different from just a general POP.
Right,
Again,
okay,
these are
but they're
residential
fairly
courtyards.
detailed as far as landscaping, hardscape, amount of
Yes.
seating,
Yes.
lighting,
Exactly.
signage.
Seating, yep.
And are they publicly accessible
They are not. They're not. They would be mostly for residents.
for building
and
residents?
for visitors. Yep.
Okay, good, thank you.
Any other questions for Oscar? Hearing none, public hearing Wednesday. Thanks, Oscar.
Thank you.
Let's now advance to item number 4, page 179, proposed zoning map and zoning text amendments. The zoning map involves a change from M12 and M13 to R7X and M12 to R7XC-1. And there's also an action to establish a mandatory inclusionary housing development. Bronx pre-hearing item number 4, page 179, and our presenter is Michael Parkinson of the Bronx office.
Good afternoon, Mr. Chairman, Commissioners. East 147th Street rezoning was certified on May 9th and is now back for pre-hearing. The East 147th Street rezoning application is a zoning map amendment requesting a change from M12 and M13 to R7X and R7X/C14 on all or portions of 17 lots on 4 blocks in the Bronx Community District, Ward 1. MIH will also be mapped as a component of the application, with the applicant recommending both options 1 and 2, which would require either 25% of a project's units to be made affordable to families making an average of 60% AMI, or 30% of a project's units being made affordable to families making an average of 80% AMI. The rezoning is being undertaken to facilitate the development of 100% affordable residential project, contingent upon securing subsidy from the city. I will note that the applicant has been engaged with HPD throughout the process. The project area is located in Community District 1 within the Mott Haven neighborhood located in the South Bronx. The East 147th Street rezoning would impact 17 lots in a geography generally bounded by Southern Boulevard to the west, Austin Place to the east, and along the northern and southern block fronts of 147th Street. The applicant-owned site is located in the northeasternmost portion of the rezoning area, here dotted in red. The area is well served by train and bus service and is located just west of the Bruckner Expressway and the elevated Bruckner Expressway. The rezoning area is located just north and west of the Port Morris Industrial Business Zone, contributing to the industrial character of many of the surrounding land uses. Additionally, the rezoning area is located only a few blocks from the regionally serving St. Mary's Park and about a mile away from the commercial and entertainment hub of the South Bronx, known as the Hub. Generally speaking, the surrounding land uses are a mix of light industrial and manufacturing uses to the east and to the south of the rezoning area, and residential and commercial uses to the north and to the west of the rezoning area. The existing zoning within the rezoning area is M12 and M13. Currently, M12 districts allow the development of industrial and commercial uses up to 2.0 FAR. M13 districts allow these same uses up to 5.0 FAR. Each district allows some community facility uses up to 4.8 and 6.5 FAR respectively. The proposed R7X district would permit residential uses up to 6.0 FAR in inclusionary housing districts, as is proposed here, with a height limit of 145 feet. One parking space is required for every 0.5 units, with no parking requirement for affordable units. The R7X district would not impose a requirement for a side yard, but would require 30-foot rear yards. Additionally, a proposed C14 district is proposed along Southern Boulevard and would allow neighborhoods serving commercial uses, and within the R7X district, a maximum FAR of 2.0. The overlay is not associated with the applicant's proposed development project. The proposed development site is a combination of 4 tax lots totaling just over 24,000 square feet on 147th Street's northern frontage between Timpson and Austin Place. The site's current zoning is M12. The site currently contains a 1-story parking garage and surface parking totaling approximately 50 parking spaces. Additionally, 2 lots of the development site contain small unoccupied residential buildings. The applicant is proposing a 12-story building, which will rise to a maximum of 125 feet, totaling 164,000 gross square feet, in compliance with the R7X district's permitted 6.0 FAR. To facilitate the project, the applicant is seeking low-income housing tax credits bond cap and subsidies from New York City Department of Housing and Preservation and the New York City Housing Development Corporation. The proposed development consists of 3 main vertical sections that create a continuous street wall and rise incrementally in 3 level changes between levels 1 through 6, 6 through 9, and 9 through 12. It peaks at the southwest corner of the development site. The proposed development would have a base height of 85 feet with floors 6 through 12 set back from the building's northern edge and floors 9 through 12 set back from the building's eastern edge. In closing, the applicant seeks rezoning of the project area from M12 and M13 to R7X and R7X/C14. In addition to the proposed mapping action, a zoning text amendment is proposed to designate the project area as a mandatory inclusionary housing area, and the proposed project is recommending the application of options 1 and 2. The proposed C14 commercial overlay along Southern Boulevard will allow for a continuous strip of commercial uses to serve nearby residents, extending from existing commercial uses north of East 147th Street along the east side of Southern Boulevard. The East 147th Street project was certified on May 9th, and Community Board 1 held a public hearing on May 26th and voted to recommend approval of the action with conditions by a count of 13-4 with none abstaining. The modifications and conditions are that the applicant obtain another rental management company than currently retained by the applicant, that the property at 860 East 147th Street, circled here, be removed from the rezoning area, that CB1 receives 50% community preference in HPD's tenant selection, that the board receives ongoing reports on how many local community board residents are hired during the construction and post-construction periods of the project, and that the applicant provide optimal greening of the project area along streets immediately surrounding the project. Subsequently, the Borough President held a public hearing on June 23rd, 2016, and voted to approve the application without modifications. Thank you.
Thanks, Michael. Questions? Ms. Delausse, followed by Ms. Efron.
Hi. Just following up on the community board's recommendation about removing one of the parcels.
That's right.
So that's currently a residential parcel, is that correct?
That parcel is actually, it has recently been demolished. It is vacant as of
Okay.
now. And there is, in the wind, proposals of a hotel on the site.
I see,
Although no approved DOB permits at this time.
I understand. But adjacent to that are two manufacturing spaces, right? According to the map.
Adjacent, there is the one, followed by other residential uses that would be made conforming. So that would be, let's see if I can do this.
Okay. And I'm
This-
assuming that the boundaries for the proposed rezoning were really determined based on looking at current use primarily?
That's right. The map as drawn reflects the land use patterns that we've been seeing today, and we think are should persist into the future.
Okay, thank you.
Thank you.
Ms. Efron.
Thanks. Could you just show us where the line of the Port Morris IBZ runs to?
Sure. If you can see this purple hatching.
Uh-huh. So it runs pretty much adjacent to
That's
this.
right.
So
So
in answer to Commissioner Delos' question, it's all but the IBZ, right? I mean, that's what the delineation is that right?
not completely,
Except for the one blue section, yeah.
but yeah, the eastern boundary certainly.
So will somebody from SBS be here to talk about how to make sure that there's a positive interaction or at least consequence for both the IBZ and the residents?
Sure. So at this point, we don't plan on, or we wouldn't anticipate SBS to testify on Wednesday. We can certainly reach out.
Well, is there anyone who's going to advocate on the IBZs or be able to even just, advocate's the wrong word, but able to speak about how it will function with residents there as opposed to having this buffer? Granted, buffering may not be the right planning action, but there is currently a low-scale buffer between the residential neighborhood and the IBZ.
Well, we do see this as sort of the eastern bookend of where that residential meets the industrial. It has certainly been functioning that way to date.
And I would just add that this side of the Port Morris IBZ, west of the Bruckner, has not seen higher intensity in industrial uses. You have existing residential on many of these sites today. And just looking at the trends in the area and what's there, they seem like the rational planning boundary.
But we can certainly check with SBS as well and see if SBS has a view on this, and if they do, whether we would invite them here to express that view,
Of course.
whatever it
And
may
they
be.
are aware.
Great.
Okay.
Thanks.
Certainly, Ms. Delausse.
And just to follow up on Commissioner Efron's point, I mean, even your own picture shows a line of 18-wheelers right at that boundary, and so.
To be fair, I didn't take the photos.
Well, I'm sure it's a
the
Google,
pictometry,
it's a Google
yeah.
map thing. But,
Is this what you're referring to?
yeah, that seems like something that should be considered for potential conflicts in use.
And Ms. Levin. What?
Were you going to say something?
No, go ahead. I defer to you.
Because I have just really a pretty minor, well, maybe it's not a minor question. I noticed that at the community board's vote, 13 in favor, 4 against. So that's only 17 people who were present at the vote, out of a total of 40 members appointed to the board. How robust was this community review? Do we feel like we really got a sense of what the community thinks about this project?
My sense from the hearing, which I did not personally attend, was that there was a robust discussion. However, most of the discussion did revolve, not necessarily around the project or the proposal, of which many people were in favor for, more about the notification process. That was sort of the topic du jour as it pertained to this project.
Was there even a quorum?
I believe there was.
What is a quorum, 20?
20%.
40%?
Well, that's a quorum for a hearing, but is that a quorum for a action by the community board? Don't they need a majority?
Yeah, let us confirm that.
Yeah. I mean, it's neither here nor there. We've got what we've got, but, you know, we've had a number of occasions where the community boards either just fill in the forms and don't send us an explanation, or, it's just really important that community boards understand they do have an advisory role, but it's a very powerful one.
Sure.
I'm not making this speech to you, I'm making it to those folks. And that the more the community boards can tell us why they think what they think, the more we can help shape a proposal that really addresses community concerns. It makes a big difference.
Absolutely. That's appreciated.
And just to Commissioner Levin's point, we'll try to schedule sometime in the not-too-distant future, but we'll have to try to find a good date to schedule it. Just a general staff presentation regarding our work with community boards in order to, well, just briefly, in order to first raise the standard of community board participation, particularly in the capital budget process and in their very important role in terms of community district needs statements, and to get a more both robust and standardized approach so that city government itself can respond in a more substantive way. So we'll try to schedule this. I think the work that staff has been doing in that area has been really significant, so we will schedule that in the near future.
That's really helpful, and if we can help staff, I know the staff is actively engaged with communities. If we can help you impress on community boards the importance of using the opportunities they have to talk to us, and the fact that we really do listen. I'll go out and tell anybody that, but
Fantastic.
sign me up.
And I would add with this, as with all of our projects, we encourage the applicant to immediately go to the community board and talk with them. And I know in this case, they did have additional conversations with the board, and Board 1 is typically very well organized. I know they.
Michael, the reason that the community board, as you understand it, voted to queue out the one site?
Yes. My understanding is that was less a reflection on their land use perspective or their desire to see or to not see any specific development on that site, rather a reaction to no formal notification process being issued to all property owners within a rezoning.
Okay. Ms. Ortiz?
Hi. Along the lines of the community board, the modifications and conditions that they've requested, really quite interesting. The very first thing is a request for or that one particular management company not be selected. I presume that can't be allowed, or to what extent is that like a
Thank you for the question. What I didn't mention that I should have is that on Wednesday, we do expect representatives from both the applicant team as well as the adjacent hotel site to come and give testimony. As part of the applicant's testimony, they can speak toward those requests. And all they've told me to this point is that they are willing to entertain multiple rental management companies. They have not committed to any at this point, as far as my understanding.
Well, Wavecrest is my management company, so I'm very interested in this conversation.
Interesting.
Any other questions for Michael?
Thank you.
Thank you.
Let's now move to item number 5, page 209, proposed acquisition and site
When
selection.
Commissioner Ortiz becomes someone who testifies, then it'll be a precedent indeed.
So we're on item number 5, page 209, proposed acquisition and site selection of property concerning the Westchester Square Branch Library, back from Community Board and Board President Review. And our presenter is Dana Driscoll, lead project manager from the Bronx office.
Good afternoon, commissioners. DCAS and the public library are seeking site selection and acquisition of the property of a portion of 9 Westchester Square, which is in the Westchester Square Neighborhood Community District 10. Sorry. This is a mixed-use community in East Bronx. Primary commercial and activity nodes, economic activity are on the east-west, East Tremont Avenue and north-south Westchester Avenue with the elevated IRT number 6 line passes through a main access point for the library. The existing library on Reade Street is old and not ADA compliant, in need of significant capital improvement, and it's not designed to work with the new approach to services by the public library. And for this reason, a new location is being sought. This graphic here shows the proposed site, which is again nearer to the main drag, if you will, and the existing library site, which is to the east and in a more residential and less prestigious and accessible site in the neighborhood. The proposal will require the subdivision of 9 Westchester Square, which is currently the site of the Huntington Free Library. This is approximately 22,000 acre site. This is the existing Free Library, which is a landmarked location at a New York City landmark. The proposal will again require a subdivision of 9 Westchester Square, and approximately 9,000 square foot portion will be subdivided, acquired by the city, and used as the site for the new proposed library. The remaining portion of the property will remain in the ownership of the Huntington Free Library. The 2 libraries will act and be developed independently. The proposal is for a 2-story, 12,000 square foot facility at this portion of 9 Westchester Square. This is a first floor plan, and basically showing the kind of open format that would allow for the new operations intended by the proposed library. This will be ADA accessible, LEED eligible, and provide for the new type of supervision and services, community room, allowing more for community meetings and less of a focus on research and library stacks. The proposal would allow for the expansion of the library inventory and better accessibility services. Community Board 10 held a public hearing and voted 31-0 with no abstentions in favor of the proposal. There are 46 members of the Community Board. In addition, the Borough President also held a public hearing and is unreservedly approving of the proposal. And this will be on for hearing on Wednesday.
Thanks, Dana. Any questions?
I've got one.
Yes,
Sorry.
please.
Commissioner Delos.
It's relatively brief. Dana, just a question about, are there plans at all to do any plantings or anything? It seems like the sidewalks are going to be pretty wide.
There will be extensive planting. There will be a landscaped front and rear yard within the design. In addition, there will be shade trees planted along the entrance area, and also passive sitting area, benches, and otherwise will be available. This will be, again, vegetation native to the area. There will be extensive landscaping. In addition, we're not
It's just,
be
I don't think we have any pictures of
This
the.
is, this is designed to maximize the use of natural light and also to provide a view corridor, if you will, to the existing Huntington Free Library next door.
Thank you.
Any other questions? Thank you, Dana.
Let's now advance to item number 6, page 227. It's a Manhattan pre-hearing application with respect to a proposed special permit to modify use regulations at 248 Lafayette Street, which is located within the Soho Cast Iron Historic District Extension. And our presenter is Bob Tuttle of the Manhattan office. Item number 6, page 227.
Good afternoon, Chairman Weisbrod, Commissioners. This is a private application for a special permit to facilitate the continued retail use within the existing building at 248 Lafayette Street, located in the Soho Cast Iron Historic District in Manhattan Community Board District 2. The special permit is pursuant to Section 74711, which is landmark preservation in all districts, and would allow for the modification of use regulations in the M1 5B zoning district. The application is returning for a public hearing following certification on April 25th and review by Manhattan Community Board 2 and the Manhattan Borough President. The project site is on a through-block lot in the Soho neighborhood, centered here on the map, and then also in the blowout here. It has frontage on Lafayette Street, Crosby Street, and then Prince to the north and Broome to the south. The project site has a total of 3,450 square feet, and the lot is improved with a 6-story and cellar building. The building was constructed in 1900 and built in the Renaissance Revival style. A restoration and maintenance plan for the building's facades would be initiated upon approval of this application. The Landmark Preservation Commission approved the proposed project in October of 2015. The applicant seeks to legalize the existing 1,390 square feet Use Group 6 retail space on the ground floor of the Lafayette side of the building, shown here in the shading, and 2,270 square feet of Use Group 6 retail space in the cellar of the Crosby Street side of the building, shown here in the shading. Each space will be for separate retailers. The building is a co-op building with JLW QA units, which are located partially on the ground floor and through the entirety of the remaining 5 floors. This approval would legalize the Use Group 6 retail use on the ground floor and cellar level of the existing building and would not impact the Use Group 17D JLW QA units throughout the remainder of the building. On May 19th, 2016, Manhattan Community Board 2 voted to issue a resolution to recommend approval of the application with a unanimous vote of 34 in favor. And on August 3rd, 2016, the Manhattan Borough President recommended approval of this application as well. Happy to answer questions at this time.
Thank you. Any questions? Commissioner Levin, a question after Manhattan Community Board 2 voted unanimously without condition?
I just want to be sure
How rare is that?
I just want to point that out, thank you, and ask if we can't reinforce, one of their conditions is that apparently the applicant has agreed to no eating or drinking establishments in the proposed retail spaces, and since this is a special permit, can we make that a condition of our approval? Is there a way to legally implement that restriction?
I can look into that.
Well, we'll start by asking the applicant at the hearing about their commitment to that, adherence to that commitment. And then
Yes.
we'll figure out what we can do about it.
Yeah.
Okay. And then one question for Jackie. Can you just swivel the projector so that we can see?
Sorry.
There. That's it. Thank you.
And I do know that the applicant apparently has made a commitment to Community Board 2 with respect to it.
They have.
So,
But since this one is a special permit, we might have ability, usually we don't have an ability to formalize those when it's like a rezoning or something, but here we might.
any other questions? Thank you.
All right, thank you.
We're now on item number 7, page 262, proposed modification to a restrictive deck to remove use restrictions on property located at 95-97 Horatio Street, Community District 2, Manhattan, back from post referral. So our presenter is Sylvia Lee, our project planner. for Manhattan. Item number 7, page 262.
Good afternoon, Chair Weisbrod, Commissioners. 9597 Horatio Street is a private application returning as a post-referral item after review by the Manhattan Community Board 2. As you may recall, the applicant seeks to modify restrictive declaration D93 to remove use restrictions and marketing requirements imposed on a 47 square foot ground floor space located within an existing building at 95 Horatio Street, within a C62A zoning district in the Gansevoort Market Historic District. The project site is located in the Meatpacking District neighborhood of Manhattan. It's a single zoning lot bounded by West Gansevoort, Washington, and Horatio Streets. The space subject to this land use application is at the northwest corner of the site, where the red dot is. Directly south of the new Whitney Museum, the site is occupied by 2 mixed-use buildings that were converted from cold storage warehouse after the site was rezoned from M15 to C62A in 1984. Currently, portions of the ground floor is occupied by a variety of retail uses and eating and drinking establishments. Until September 2012, Weishel Beef had been the tenant of the corner space, subject to the RD. In 2012, the business relocated to the Meatpacking Co-op, a block north, which is shown on this aerial map. The space has since been renovated and is currently vacant. Over the years, the surrounding neighborhood has seen a substantial reduction in meat-related establishments, an increase in residential, retail, eating and drinking, arts and culture, office, hotel, and other commercial uses. Today, the Meatpacking District, generally to the north and east of the site, is characterized by upscale retail shopping, dining, nightlife, and a mix of commercial and residential buildings of varied scale. The area south of the site is generally more residential. At the review session before the referral, the Commission had questions about the status of the meatpacking industry in the surrounding area. Staff spoke with the Gansevoort Meat Market Co-op and the meatpacking bid. It was confirmed that the only active meatpackers in the area are in the Gansevoort Meatpacking Cooperative. The co-op facility is currently accommodating 6 to 7 meatpacking businesses that principally cater to high-end restaurants and butcher shops in Manhattan, some in New Jersey. So that 7 meatpackers include the former tenant of 95 Horatio Street. The president of the Meat Market Co-op also stated that that there doesn't seem to be an increasing demand for meatpacking spaces in the area. The quarterly census of employment wages data from the Department of Labor also confirms that meatpacking employment in this area has been in decline for the past decades. So a little reminder on the RD the applicant seeks to modify. D93, along with other 3 RDs shown on the sketch map, was entered into as part of the rezoning to mitigate potential environmental impacts on land use, neighborhood character, and meat-related businesses. These RDs generally include bulk regulations and use restrictions in certain defined industrial space, which were at the time the rezoning still occupied by meatpackers. Since the rezoning, 2 modifications to D94 to extend the permitted uses have been approved. In addition to restrictions relating to bulk, D93, which was recorded against the project site, obligates the property owner to maintain the use of the 4,700 square foot ground floor industrial space for meat-related uses, and in the event of vacancy, to use best efforts to rent to such uses. If such tenants cannot be found, the space could then be utilized for other light industrial uses listed in the restrictive declaration. This was what the exterior of the industrial space looked like before the relocation of Weishel Beef. Afterwards, also after the Whitney Museum was constructed. The applicant proposes to re-tenant the space outlined in red, plus the cellar for a restaurant, retail, or other uses permitted by the underlying C62A zoning district. Note that only this hatched area is subject to this RD. To facilitate such proposed development, the applicant seeks the approval of the modification to D93 to remove the entirety of the use restrictions and marketing requirements in the deck. The application was certified and referred out to Community Board 2 on April 15th for 45 days, which was then extended by about 2 months at the request of the applicant and the Community Board 2. At its full board meeting on July 21st, 2016, Manhattan Community Board 2 adopted a resolution recommending approval of the application with the following conditions. 1, D93 is amended to allow commercial and/or retail uses excluding nightclubs and eating and drinking establishments. 2, a new restrictive declaration is recorded pertaining to 91 Horatio Street, which is shown the location of the wet dot in this map, limiting its use to educational, cultural, and arts nonprofit uses and/or those that provide nonprofit services of benefit to the local community, and assuring that all future leases will be at preferential rent. Prior to the community board vote, the applicant agreed to make the following commitments if the use restrictions are eliminated, summarized in the applicant's letter, which is included in your briefing packages. The applicant would limit the use of the industrial space to prohibit nightclubs and also limit the hours of operation and prohibit late-night business hours. Second, the applicant would provide a benefit to the community by leasing the approximately 5,000 square foot space located at 91 Horatio Street to only not-for-profit, cultural, educational, and arts tenants. The applicant's statement and related correspondences are included in your briefing packages. There is one additional letter from Greenwich Village Community Task Force, which should be in front of you. That was submitted over the weekend.
Thank you, Sylvia. Questions? Commissioner Delausse and Commissioner Ortiz.
Sylvia, just a number of these things seem like they might be outside of our purview, so I'm just wondering what the community board is hoping in terms of memorializing some of these things. And I'd be interested, for instance, if there was discussion about what a preferential rent looks like for such a situation, for such a long-term situation. I mean, I think it's creative, and I applaud them. I'm just wondering how far the thinking has gone. Perhaps they can share that on Wednesday.
With regards to preferential rent, I think the applicant team would probably be able to provide more information later. I'll follow up. Staff took a look at these additional restrictions that were proposed by the community board and believe that there might be scope issues. Staff will look into it some more and provide additional follow-ups.
I think it's fairly clear that preferential rents are beyond our jurisdiction.
Yes.
Commissioner Ortiz and Commissioner Efron.
Yeah, along the lines of my question was related to how, to what extent can these or be legally binding, or are they outside of scope? But I had another question. Is this within the bid boundaries, the meatpacking district bid boundaries?
I believe it should, I might need to double check. I don't remember.
Okay.
Sorry.
That would be interesting to know, because we recently saw the meatpacking bid come before us, and I know one of the issues was helping to manage the increase in conflict between residents and businesses, and the goal was that they would somehow be, my understanding was they would play a role in helping to address those issues. So I'm curious where this is within the bid district. Where does the bid stand on this particular issue? Thank you.
I just want to say thank you for the hard staff work on finding the information about the meat packers. But as at certification, I am concerned that there was a restrictive declaration and that a developer or an owner of the property at some point did rip out the refrigeration, which presumably had value to its use. And I don't know if there's any information that city planning has with regard to any conversations that would shed light onto whether or not the owner was aware of the restrictive declaration, but shouldn't the owner have been aware of the restrictive declaration?
Is that a rhetorical question? Or?
Let me just.
I assume,
I'm
given
just
the-
expressing my concern that we're rewarding bad behavior.
I think it's, fair to take notice here that the owner-developer is a reasonably sophisticated owner-developer who presumably knows the restrictions on its property. Other questions for Sylvia? Sylvia, do we know who will be here to testify on Wednesday?
This is an item that does not require a public hearing.
Oh, so this is, I see, right. This is going to be scheduled for a vote. So we need to get answers to the questions that the commissioners have raised, and I also, just to reiterate what Commissioner Ortiz raised, I would very much like to know what the if the meatpacking bid did take a position on this, and if so, what it is.
Right, will do. Thank you.
Thank you. Okay, so moving on now to item number 8, page 330. It's the Empire State Development General Project Plan and Design Guidelines for the Women's Building at 550 West 20th Street. And Carolina is our presenter from the Manhattan office.
Good afternoon, Commissioners. Empire State Development proposes a general project plan, or GPP, and design guidelines for the long-term lease and redevelopment of the former Bayview Women's Correctional Facility at the Women's Building at 550 West 20th Street in West Chelsea in Manhattan Community District 4. The GPP requires override of several New York City zoning regulation and is therefore subject to the Commission's review. The former Bayview Correctional Facility on the corner of, 11th Avenue and West 20th Street in West Chelsea comprises 2 buildings, the main building at the western end of the site, as well as the laundry facility at the eastern end of the site. The site is under the ownership of the New York State Urban Development Corporation, doing business as Empire State Development. This aerial again shows the project site on 11th Avenue and West 20th Street, and the main building occupying the majority of the site on the west, and the laundry facility, the lower-rise building on the east. These images show the main building taken from Route 9A, parallel to 11th Avenue, with a 250-foot tall residential building bordering to the south of the main building site. This is the mid-block. This shows the main building at the right hand of the image, and then the laundry facility, a 6-story building on the left side of the image. And this is a shot looking east on West 20th Street towards the High Line at the end of the block. The current buildings, which are eligible for listing on the state and national registers, were constructed in 1931 as a Siemens YMCA, with main building used as a dormitory and the east building used as a laundry facility. In the 60s and 70s, the site served as a Narcotic Addiction Control Commission and was transferred to the State Department of Corrections and Community Supervision in 1974 as a correctional facility. The site was evacuated shortly before Hurricane Sandy in October 2012 and decommissioned by the governor a year later. Damage from the hurricane, deterioration, and facility consolidation led the state to issue an RFP for the facility's purchase or long-term lease and adaptive reuse in May 2014. The RFP required adaptive reuse of as much of the site as possible, the inclusion of some community facility use, and prohibited residential use. In the spring of 2015, ESD signed an MOU with the Novo Foundation, a women's rights advocacy organization, to redevelop the site as the Women's Building. The project site is a 15,800 square foot site with 190 feet of frontage on West 20th Street and 9 feet of frontage on 11th Avenue. It is occupied again by two buildings, the 87-foot tall main building fronting on 11th and 20th Street, and the adjacent 6-story facility in the mid-block on 20th Street. Originally mapped in manufacturing district, the project site and surrounding blocks were included in the 2005 Special West Chelsea District zoning map and text amendments to encourage the neighborhood's growth as a dynamic mixed-use district. West Chelsea continues to be actively developed with residential and commercial buildings along 11th Avenue and 10th Avenue, and blocks where commercial districts are mapped. Mid-blocks and manufacturing zones are largely occupied by lower-rise loft buildings and with office uses or art galleries. The Chelsea Pier Sports and Entertainment Complex is across Route 9A, just adjacent to the project site, and the High Line runs along just west of 10th Avenue over the project block. The project block includes a single-story gallery immediately east of the project site, which is being redeveloped with the residential project, a 4-story garage mixed commercial building, a low-rise converted church, and a leasing office at the eastern end on 20th Street. Fronting on 19th Street, again, is a 250-foot tall residential, commercial, largely residential property at the corner of 11th and 19th Street. In the mid-block is a single-story residential building, a low-rise row house, and then a newly constructed residential property flanking the High Line. The Special West Chelsea District zoning map amendment mapped the subject zoning lot in 2 districts. The entire main building is mapped in the C63 sub-area D district. The laundry facility is diagonally split, with the western portion C63 sub-area D and the eastern and C62 sub-area E. This site plan more clearly shows the diagonal split across the current laundry facility building. C63 sub-area D, in the western portion, permits up to a 7.5 FAR of residential and commercial floor area that includes 2.5 FAR of Highline Transfer Corridor floor area, or in combination with inclusionary housing floor area. Envelope regulations require a base of up to 90 feet and a building height of up to 250 feet. C62 sub-area E, mapped over the easternmost portion, permits 6 FAR of residential with residential commercial floor area with 1 FAR from the Highline Transfer Corridor. Buildings must have a base of between 60 and 105 feet and are limited to 120 feet in total height. The proposal involves a rehabilitation without enlargement of the main building at 11th and 20th, and the demolition of the laundry facility to be replaced with a new approximately 16-story, 56,000 square foot building on the western segment of the site. The entire facility will host a dozen or more women-focused organizations and provide groups with resources to co-locate office space, share facilities for lectures, conferences, performances, and art display. In total, the site will include 118,493 zoning square feet, comprised of approximately 42,000 gross square feet of office for nonprofits, 9,000 gross square feet of office space for for-profit organizations, 6,000 gross square foot restaurant or cafe, as well as several spaces for accessory to the community facility programming, including a health clinic and wellness center, child care facilities, an event space, roof, garden space, and small art gallery. These facilities will occupy both the refurbished main building and the new laundry facility replacement, and together constitute the women's building. The GPP and design guidelines prepared by ESD represent the maximum envelope within which the entire site will be designed, as well as the replacement laundry facility. The envelope expects that the main building will remain in its current form, with renovations to its facade and floors and reconfiguration of interior space without increasing or enlarging the main building envelope. The laundry facility will be replaced with a building of 190 feet in total height, that sets back a depth of 15 feet at 120 feet. The building is intended to also occupy the rear yard up to a height of 30 feet, setback 10.5 feet, rise another up to 75 feet, and then setback to a depth of 15 feet from the rear yard line. The redevelopment and programming of the site override floor area, height and setback, rear yard permitted use, and sign regulations. Novo Foundation and the partnering developer recently selected an architect to design the building. The GPP defines a maximum envelope within which the replacement facility will be designed. In addition to the modifications outlined, the design guidelines prohibit residential and transient hotel uses on the zoning lot. The lease and GPP also stipulate that the tenant demonstrate that no more than 25% of the space be used for for-profit uses. The remainder must be used for non-for-profit use. ESD proposes to apply a uniform 7.5 FAR across the entire zoning lot to allow for the most efficient reuse of the site and redevelopment of the laundry facility. The laundry facility segment will be constructed with all of the available floor area generated by that portion of the site, as well as unused floor area from the main building. In the C63 subarea D district, to allow an increase of floor area above a base of 5 FAR, 7.5 FAR is proposed without the use of Highline Transfer Corridor floor area. In the C62 subarea E district, to allow an increase of up to 7.5 FAR would mean an increase above the 6 permitted as a maximum in the district, and again, no use of the Highline Transfer Corridor floor area. The height and setback overrides on the laundry facility segment will allow the full utilization of the 7.5 FAR and leave the main building intact, with no overbuild affecting the corner structure. To improve efficiency, the base heights of the addition are proposed to match the base height of the main building and align floor plates to allow seamless access between the two buildings. In the C63 subarea D portion, the waivers of which are shown on the left-hand side, the maximum base height permitted in the district is 90 feet. The base is proposed to rise to 120 feet, and the tower portion is also proposed not to include required tapering within the top 40 feet. In the C62 subarea D portion, the waivers are shown on the right-hand side. The maximum base height permitted is 105 feet. Again, the base would rise to 120, and the maximum overall building height is 120. Here, 190 feet is proposed. Rear yard regulations are also proposed to be overridden. In C63 district, a 20-foot rear yard is required. Here, the rear yard would rise over the entire lot up to 30 feet. Again, setback 10.5 feet before rising another 75, and then provide a 15-foot rear yard above 75 feet. The bulk waivers are shown in blue in this axonometric model. The project proposes that the proposed uses that support the Women's Building nonprofit program, including a gym and wellness center, as well as outdoor space and a greenhouse for a rooftop greenhouse for plant cultivation on the roof. Finally, sign regulations would be overridden to allow a series of banner signs on West 20th Street displaying the names of building occupants, and a replica historic sign would also be located on 11th Avenue. In order to accommodate these signs, the 500 square foot cap for non-illuminated signs would be increased to 590 feet on West 20th Street, and signs would be permitted to project 4 feet at a height of 87 feet rather than a maximum of 18 inches at a height of 40 feet. Overall, staff supports the ESD and Novo Foundation's mission to repurpose the project site as a women's building, to be a resource for organizations that work to advance women's rights. Generally, staff believes that the project is appropriate, but would encourage the development team to explore the location of floor area in the C63 subarea D district as an enlargement of the main building. An addition of the floor area to the main building would relieve the degree of height waiver needed for the laundry facility replacement building. The main building is 87 feet tall and is in a zoning district that permits a height of 250 feet. The 2005 Special West Chelsea District Report describes sub-area E, lower rise envelope with heights of up to 120 feet as a transition between higher densities and heights within sub-area D and lower scale area of Chelsea east of 10th Avenue. While staff appreciates the goal of preserving the historic integrity of the main building, an addition could be designed to be sensitive to the historic building character. I'm happy to answer any questions.
Yes, Caroline, I have a question about the timetable here. I mean, we are obviously requested to make comments pursuant to ESD's GPP timetable. Do we know what that timetable is? And
The public comment period is currently open, and it ends on August 26th.
August 26th?
That's right.
Because I note that there is a letter from the community board, also generally supportive of the project, but wanting some additional time to respond to the zoning overrides and other things. Have we gotten additional comments from the community board?
The community board hasn't provided additional comments, but we know that ESD is in discussions with the community board about setting up a public meeting, and that date hasn't been formalized, but I know that there's an intention to present publicly to the community board.
Would that presumably be before the 26th?
That ideally would be before the 26th.
And before our session on the 22nd?
I can follow up about that.
Thanks. Commissioner Efron, then Commissioner Levin, then Commissioner Delarose.
I defer to.
Commissioner Levin, then Commissioner Efron.
Well, so
then
just
Commissioner-
following up on that, I know that there's a public comment period, but does that apply to us too, or do
No.
we have a separate clock?
It's 1 o'clock. The commission's letter would have to be received by the 26th.
Okay, well, my very strong preference would be to wait to say anything until we've heard what the community board has to say, but that might not happen.
Well, there is a...
In which case,
yeah.
I have a list of comments to put out there, but.
Well, I think we don't, it is now August 8th. We have a limited amount of time to prepare our own comments or modify even draft comments that staff has prepared. So presumably, the community board will act in or respond expeditiously, but if not, we have a responsibility, if we want our views to be reflected, to respond within the timetable that ESD has. That's...
I was afraid that was the case.
No.
So I
Commissioner
have a list, but I'll,
Okay. And comments from the commission obviously are welcome, and when we get, commissioners are welcome, and if we get comments from the community board, obviously we'll share them with everybody.
I just have a question about who's developing it. It says that it's a net lease, presumably from ESDC. It looks like a fairly complicated development, and it's for a nonprofit. So if it is a nonprofit developer, or even if it's a for-profit developer, then leasing space to nonprofits, what happens if it doesn't come together? Would all of these rights continue to exist, including banners and all, or is it only in the case that it's the intended use of the nonprofit Women's Center?
Sure. So the Novo Foundation is actually partnered with Gorin Group, who will be, together they'll be developing the site. If the MOU and the agreements that ESD has in place with the project partners falls through, then ESD would either have to revisit the respondents to the original 2014 RFP and see whether an alternative plan can be developed for the site, in which case that would likely involve a new set of waivers and overrides and would come back to the commission, or there would have to be an entirely new RFP issued, which again would involve a revisit of the waivers. So these waivers are pretty specific to this selected respondent.
Thank you.
Just to follow up on Commissioner Efron's question, the GPP, is the GPP limited to this particular respondent? So in other words, if another, I mean, I know that ESD's intent is if this does not materialize, they would presumably come back with another set of waivers or another use or whatever, but if another respondent complied with this GPP, would that process start again? Okay.
I will ask about that, whether it is in fact tied solely to this respondent. My understanding was it relies on the scope of waivers, and it's the scope of waivers that informs whether or not there has to be a return to the process. But I will follow up about that.
Thank you. Commissioner Deluz.
So Carolina, was there an EIS done for this? And what level of impacts did it outline for the project?
There was an EAS prepared, and it was a negative declaration.
So no issues
There
at
are
all?
no impacts.
Okay. And this is going to be a lease, right?
It's a long-term lease, 99-year lease.
Okay, and this is in a flood zone, correct?
It is in the 100-year flood zone. That's right. So the buildings will have to comply with Appendix G.
Thank you.
Any other questions, Commissioner Levin?
Okay, you want to hear my little list?
I'm ready.
First off, my own thoughts align with what you articulated as staff's thoughts here. I think it's great that we've come up with a proposal that's making use of the existing building, figuring out how to repurpose it, but let it be in place. And it seems like a very good proposal. I think our letter should lean a little more heavily. You, in your presentation, said a little more strongly on what the planning notions are behind the special West Chelsea rezoning. In other words, the idea that the height is to be concentrated on the avenues and the donut hole, if you will, is to be the lower scale, and that is an important planning principle here. We're essentially being asked to allow them to build to a 7.5 FAR, which is, the full bonus FAR, if you will. So we're accepting that that's an appropriate density because it's planned for in the Special West Chelsea District, but they're being allowed to use it without providing the public benefits that normally would come from the as-of-right use of that FAR, which is sucking up the Highline transferable development rights and/or including affordable housing under the inclusionary housing program. So, I think we have to acknowledge that supporting this project means we're accepting this package of uses as a comparable public benefit to those other features that would give rise to this density. In other words, I think our letter should make it clear that that's our trade-off here and that there is a public benefit to doing this. We don't want to invite future overrides that don't have that kind of a strong public purpose to it. I think we should make it clear that preservation of the existing building is essential to our support of this package of overrides. I think you're absolutely on the right track, trying to essentially reduce the height of the new building by encouraging some kind of an overbuild. If you look at the shape of the existing building, it certainly looks as if it ought to be possible to include some of the new floor area as part on the main building parcel so that you could bring down, I'm very concerned about the height of the laundry building replacement. Although we can note that it backs up to the Jean Nouvel building on 19th Street, so that is a mitigating factor here. But I think the more floor area you could move off of that new building, the better it would fulfill the planning goals of the special West Chelsea district. We should emphasize that all of these overrides are only for community facility use. You said not-for-profit use. I think it should be for community facility use, too. I mean, I don't think we want to see it turned into housing.
Housing is specifically
It's specifically excluded, that's right. And then I would add, then I have a question about what the impact on the adjacent building is of the rear yard override.
Of the Jean Nouvel building?
Yeah,
So the.
are there, I know they have windows facing north, but,
They do. So the existing laundry facility building is actually occupies the full lot, and so they.
Already?
Already, and is 6 stories. And so the proposed condition is actually an improvement.
okay, all right. That's it for me.
Any other questions, Carolina? Okay, thank you,
you.
Carolina.
Let's now move to item number 9, page 344. It's a proposed authorization and a modification to a previously approved authorization with respect to facilitating a single-family home in the special South Richmond district on Bradford Avenue. And our presenter is Barry Fisher of the Staten Island office.
Good afternoon, Commissioners. The applicant requests a modification to a previously approved commission authorization for waiver of bulk regulations within unimproved streets, and a new commission authorization for modification of existing topography in special area LL of Staten Island's community district of the special South Richmond Development District in Staten Island in order to facilitate the development of one single-family home within an R3X zoning district in the Pleasant Plains area of Staten Island's Community District 3. The 77,000 square foot project area was granted commission approval in 2008 for waiver of bulk regulations for developments within unimproved streets, modification of existing topography in South Richmond, and certification of future subdivision into 11 zoning lots in order to facilitate the construction of 11 new detached homes, some single-family, some two-family, with a private road and a turnaround. One of those new zoning lots created at that time had a vacant tax lot. Now, in the current application, the applicant proposes construction of one additional single-family home within that existing zoning lot on the vacant 8,000 square foot tax lot by requesting modification to the previously approved authorization for waiver of bulk regulations with, for developments within unimproved streets, and a new authorization for modification of existing topography in South Richmond. The project area is surrounded by Drumgoole Road to the north, which is a service road for the Korean War Veterans Memorial Parkway. And on either side are streets Minturn Avenue and McGuire Avenue. A mapped but unimproved portion of Fonda Place extends into this site and along rear yards of adjacent properties to the south. The entire area south of the highway is zoned R3X and consists of detached homes, single and two-family. North of this site is Bloomingdale Park. Within the project area, 11 detached homes and the private road of Bradford Avenue were previously approved by the commission. The access to the private road is from Minturn Avenue, and it ends in a turnaround. These 11 homes were constructed. The site is within Special South Richmond Special Area LL, stands for large lots, which normally requires 5,700 square foot minimum lot size versus a 4,750 minimum lot size for these sorts of 3-story buildings in South Richmond. However, this application process had started prior to the Special Area LL being adopted, so this site is grandfathered from those requirements, and lot size ended up varying from 5,200 to about 8,000 square feet. The vacant site is this 8,000 square foot triangular shaped tax lot. At the commission's request in the prior approval, a note was added to the site plan to help ensure commission review of any new home proposed on the vacant site for neighborhood character concerns. The note on the drawing stated, "This drawing may be modified or amended only after review and approval of the City Planning Commission." According to the applicant, that tax lot was left vacant due to a property dispute with an adjacent property that was ongoing at the time but has now been resolved. The development site is an existing zoning lot, roughly 14,000 square feet, encompassing tax lots 8 and tax lot 115. Tax lot 8 is the wooded vacant site, again, 8,000 square feet. It has 278 feet of frontage on Drumgoole Road Service Road and 60 feet of frontage of this Bradford Avenue and 232 feet of frontage to the rear yards that are adjacent to the south and outside of this site. Tax lot 115, within the same zoning lot, extends into the turnaround of the mapped but unimproved Fonda Place. And the commission approval in 2008 included a waiver of bulk regulations to build the house like this close to the unimproved street. There are 34 existing trees on the zoning lot, totaling 61 tree credits in South Richmond. The applicant proposes to construct a roughly 1,600 square foot single-family home on tax lot 8 and modify grades around the home to be more level with Bradford Avenue. A driveway would access the tax lot from the existing private road turnaround, and the proposed home would be set back from Drumgoole Road by 20 feet to meet the setback requirement for arterials in South Richmond. In order to meet those constraints, the proposed home is narrower than surrounding homes at 20 feet wide in front, 10 foot wide in the rear. Regarding neighborhood character concerns, the applicant has noted that this proposal meets all zoning, yard, and bulk requirements, and that a proposed fence along this property line along Drumgoole Road would help limit the views from the adjacent service road. To facilitate this proposal, the applicant requests modification of the prior commission authorization for waiver of bulk regulations within unimproved streets in order to amend the previously approved site plan, and as per the commission's request. And the site plan, of course, is amended to include this single-family house. This request will not require any changes to the prior bulk waivers or any additional bulk waivers from the prior commission approval. The applicant also requests new commission authorization for modification of existing topography around the site, which anywhere in the Special South Richmond Development District, an authorization is required for modification of topography of 2 feet or more. According to the applicant, the home is in a 3 to 5 foot depression, needs to be raised more than 2 feet to meet the Bradford Avenue elevation. A retaining wall of less than 1 foot is proposed along the southern lot line. Elevations for the proposed home further illustrate the front view elevation, 20 foot wide from Bradford Avenue. It's narrow as 10 feet from the opposite side. And directly facing Drumgoole Road, it's 57 feet in width. The proposal would leave 13 trees worth 27 tree credits to remain, meeting the requirement for tree preservation in South Richmond.
Thank you, Barry. I suspect some commissioners on my physical right may have some comments about this. So. Start with Commissioner Cirillo.
Okay, so, thank you, Barry. We're all very familiar that these authorizations come to us. There's many of them that come to us. And no matter the hundreds that I've seen probably in the last 12 years, this is very clear to me. And I remember this very well. And I think it's important. I'm going to do my best not to pass judgment on it, since this is a non-ULUP referral, and we'll be very interested in hearing what the community board has to say, and obviously whatever discussions are entertained by the borough president on this, but I think it's very important for us as an institution to put some history to this, because it sounds to me like history may have been rewritten a little bit on this item, or at least is repackaged. So my recollection, and again, this was 2008, Barry, is that right?
That's right.
Okay, so, could be vague, and I'm willing to be corrected on the facts and my memory, but the idea that this is sort of a new application is sort of misleading, point number one. What's coming to us now is actually what was brought to us in 2008. The 12th house was part of the original site plan on this triangle. Please stop me at any point where I'm not stating the facts correctly.
Brett, just to correct, well, the application that was brought to the commission did not include it, the house was there prior to.
Correct, okay, correct. So I should say this because there were discussions before it came to the commission in reviews that had a 12th house on that lot. There was a great deal of concern. This was before Rayanne was on the commission, and her predecessor, who really drove this issue, but I certainly did not disagree, had a great deal of difficulty embracing the concept in a development as beautiful as this development is, of sticking, for lack of a better planning expression, a house that potentially would, as we see today, actually be 10 feet in width at any given point, never mind the back of the house. And there were lots of discussions about what that triangle could be used for, perhaps public space for the community or the community around it. It's also located on the service road of the Korean War Veterans Memorial Parkway. And again, in all honesty, and maybe sensitively to the issue of bad design that the borough has seen a great deal of over the years, houses built and squeezed into little, even if the amount of space around the house is sufficient, the concept of development, you could see it in many different neighborhoods throughout the city, but particularly the sensitivity here, which led to lower density, all the planning work that the department staff has spent with the elected officials. The reality was this just seemed like a really silly idea to stick this house in, and the applicant, after a long time in discussing this issue, removed the house from the site plan. So what was built was what was approved, as we know, because that's how it's being presented today. The reality is, never once during that period of time did anyone discuss any challenge between property lines with any other owner. That's a new issue today. The reason it was withdrawn was because it wasn't going to get approved with the 12th house. It had nothing to do with whatever today's reason was for it coming back to us, because now it seems perhaps it has resolved itself. I don't know, because it's a new fact I don't know anything about. So, God bless the opportunity to come back and get another bite out of the apple. Perhaps there was an expectation that no one would still be here who remembers this. Always possible. But, again, it sounds judgmental, but without judging it, I think it's important for us as an institution to understand where the commission was at the time. That doesn't mean anyone would still be in the same place today. We would also benefit, obviously, from the community's point of view on this, which this process is beginning so that we can do that. But there is, I personally haven't changed my sense that this is just not a good idea. But again, that's judgmental. So I'll listen to see what everybody has to say on this, but the idea that this is just, a revisit of a site plan, that now there's a good idea to put a house on there, we've been down that road, and And the reason we're here, and keep in mind that language that's on the approval, which I don't have in front of me, but it said that the site plan could not be changed without the approval of the commission.
Review and approval of the commission.
Correct, that wasn't an accidental. That was specifically crafted because there was a concern that perhaps 8 years later, we might have the situation. So there's reasons for all of these things. Again, how it plays out, the process will, go on and we'll figure it out. But I do think that it was important to have perspective on this since there were only actually a few of us, and because by the time it got to us, a lot of the discussion was sort of backstage, not unofficial, but what I mean is it didn't all happen here, although we did discuss this, and the modification made to the original plan during the review session that the original authorization was granted. So that was all, done properly and obviously with full disclosure. But the way this is presented is somewhat not necessarily completely accurate in how it went through the process the last time around. So that's, again, be anxious to hear what the community has to say and perhaps the borough president, and we'll see how it plays out.
Well, I guess you can put Commissioner Cirillo down as undecided. Commissioner Besser?
Thank you, Chair. I wasn't on the commission in 2008, so thank you so much, Fred, Commissioner Cirillo, for the thorough, detailed explanation. Other than the fence, the issue with the fence dispute, are there any other changes from this proposal versus the last application?
From my awareness, it looks similar to the prior layout. I wouldn't say that there were any distinguishing features in the overall dimensions of the house.
But I would also note that the application that came before the commission last time didn't actually have a house. That's
Correct. And just the dimensions of the house again, it's 10 feet in the back wide. And it's
If I
what,
could-
in the front?
The house is constrained by a 20-foot setback from Drumgoole Road, which is setback required along arterials in the South Richmond, Special South Richmond Development District. There's, of course, a front yard constraint, and that's, the applicant obviously wanted to accomplish X amount of floor footprint, and that's it gets 10 feet for this footprint area apparently is the maximum that he can get due to the 20-foot setback along Drumgoole Road.
Right, but I'm sorry. So the back of the house is 10 feet.
Right.
The front of the house is how wide?
Is 20 feet in front.
20 feet to 10 feet.
Right.
Okay. And how long is the house?
57 feet is measured along this facade here.
It's like a funnel house. It's a funnel house. Yeah.
Commissioner Besser?
Sorry. So the houses that are located on the 3 lots on Fonda Place, and how does the relationship meet? Is that the rear yards and then a side yard on one of the lots on Fonda Place?
Waivers of bulk were previously applied for, and it shows up better in this. Because the street bed of Fonda Place is this circular turnaround shape, and the applicant had obtained prior BSA approval for building these 2 houses in the bed of this mapped but unimproved street. And all 3 of these homes, because this street bed goes into this rear, required rear yard, bulk waivers were also requested and granted by the commission for this house. So this house is on the same zoning lot as the proposed house.
I'm sorry, but there are additional houses to the left on Fonda Place. correct?
Existing
There's-
homes, below the triangle, the existing homes.
Over the, in the big white.
Yeah. Yeah.
So I'm just trying to see the relationship between the existing houses on Fonda Place, right adjacent to the subject property.
Mhm.
Like,
So their backyards are.
are
on
they
the
rear
side
yards?
yard.
Do they have 30 feet? I'm just trying to understand.
Yeah, these homes here, just south of the vacant site, presumably have 30-foot rear yards. I wouldn't, guess anything else, from looking at the aerial. The proposed house meets the side yard requirement, because if this lot line here is a side yard line,
Mhm.
and so it meets the 5-foot side yard setback there. But adjacent here are the 30-foot, at least the 30-foot required rear yards.
Okay.
Any other comments? Mr. Cantor?
Yeah, question. Executive summary. When this was presented, there was a great deal of discussion, and it was agreed that there would not be a 12th house.
Correct.
Now they're coming for another bite to try and get the same thing changed back to the 12th house?
Correct.
Thank you.
I should have let you explain.
I just note that Commissioner Cantor had asked that question of Ms. Commissioner Cirillo as opposed to,
Oh, yeah, sorry, yeah, we just had our own.
We didn't discuss
that's,
it.
nevertheless. Any other questions for Barry? Hearing none, this will be referred out to the community board for 45 days, and we'll see what they have to say about this matter. Thanks, Barry.
Commissioners, before we proceed to the future votes discussion, we'll have a discussion by Anita Lamont with you with respect to a letter dated July 19, 2016, for the Manhattan Borough President and Council Member Margaret Chin regarding the lifting of deed restrictions from formerly city-owned property.
Good afternoon. I'm sure that you are all aware of the controversy surrounding the city's removal of the deed restriction it had imposed related to the 45 Rivington Street property in Manhattan. The lifting of deed restrictions for that previously city-owned property has been the subject of a New York City Department of Investigations review, a report by the New York City Controller, and many press reports. Additionally, the city administration has undertaken its own review of the process for deed restriction removal and has proposed a revised policy for the amendment of such restrictions. Today, I'm here to discuss how all of this relates to the commission. As Jackie indicated, you each received a copy of a letter dated July 19, 2016, addressed to the commission from Manhattan Borough President Gail Brewer and Councilwoman Margaret Chin. The letter urges the commission to submit a proposal to the city council pursuant to section 197C12 of the city charter to make any amendment or removal of deed restrictions imposed on property formerly owned by the city subject to ULURP. The charter provision referenced in the letter is a little known and, as I understand it, never used provision that allows for the expansion of the types of matters subject to ULURP beyond those enumerated in the charter via the enactment of a local law by the city council, but only upon the recommendation of the commission. I understand that this provision was added as part of the 1988 charter revision, at which time it was thought that allowing for an expansion of ULURP under such a mechanism where the commission initiates and the council ratifies via local law would strike an appropriate balance between the professional planning and the political realms and would mimic the sequence of the ULURP process itself. The commission currently acts on the modification or removal of deed restrictions only where they are proposed as modifications to ULURP imposed restrictions in connection with city disposition actions. For deed restriction amendments for older matters, that were the subject of Board of Estimate approval, the commission has acted on those matters where the deed restriction has been determined to have originated as a land use matter rather than as a business term of a disposition. Whether a deed restriction amendment was imposed as a business term or as a land use matter is determined in consultation with the law department based on its review of the Board of Estimate disposition record. The mayor has jurisdiction over the modification of business terms, and DCAS's procedure processes such matters along with other non-ULURP deed restriction amendments. I should clarify here that the Rivington House deed restriction was imposed outside of ULURP, pursuant to the mayor's authority under state law to dispose of city-owned land to a nursing home without public auction. The city has recently proposed a new administrative process for the amendment of deed restrictions that are within DCAS's purview. The administration's proposed revised policy addresses key issues raised by the Rivington transaction by requiring greater scrutiny of requests to modify deed restrictions to ensure that they advance city policy goals. Focus on financial considerations to the city will be secondary. Only in very rare cases will a deed restriction be removed entirely. DCAS will include legally binding language regarding the proposed use of the property in any revised deed restrictions. There will be a financial review and due diligence process, including mandated consultation with other city agencies to determine whether there are alternative uses for the property in question or policy needs of the city that may be advanced through the deed restriction modification. Most importantly, a new layer of oversight review will be imposed, with DCAS required to present any recommendations to modify a deed restriction to a committee composed of representatives of the first deputy mayor, the deputy mayor for housing and economic development, the law department, Office of Management and Budget, and city planning. Based on DCAS's due diligence, the committee will make a recommendation to the mayor prior to final action on the proposed amendment to the deed restriction. Presumably, DCP's role will be to ensure that any land use concerns are taken into consideration. We believe this proposed new process is designed to ensure an appropriately robust consideration of these matters that are within the executive's purview. Indeed, I believe that the controller's review of the Rivington House matter confirms this view, since the controller concluded that poor execution of city processes was to blame for the result, rather than the processes themselves being lacking. I would offer that to suggest that the commission should recommend that all deed restriction amendments be reviewed through ULURP, ignores the differing origins and nature of such restrictions, and would bring many matters where land use considerations were not the primary impetus for the restrictions into ULURP's purview. I am now happy to open the floor to you and to take any questions that you might have about this.
Questions? Commissioner Deluz, and, well, let me start with the Vice Chairman, and then Commissioner Deluz.
When would, assuming the proposed language was adopted, when would this become effective?
Well, there's a rulemaking process that has to be gone through, and as soon as that is completed, it would be effective.
That's the APA, isn't it, that rulemaking?
Kappa.
Yes,
Kappa.
CAPA process.
Yeah.
Mhm.
Okay.
What does that stand for?
Commissioner Deluz.
For those of us who don't know what CAPA is, maybe you could enlighten us.
Sorry, it's the City Administrative
Okay.
Procedure Act, which is what you have to do to promulgate rules.
Okay, great, thank you. So, Anita, if I follow the rationale, what you just said, if the restriction was put in place, though, based on a land use rationale, then would?
It would come to us, yes.
Okay.
Mhm. And that said, it is not always that easy to define, because particularly with Board of Estimate, matters, the records vary in terms of their thoroughness, but the effort is made to try to determine how it was, imposed.
Commissioner Dwyer.
Perhaps as a suggestion, I know that the secondary goal is financial from the perhaps maybe having a representative of the controller's office sit on that committee.
Well, there is Office of Management and Budget on that committee, which their role ostensibly is to consider the financial implications of things.
And these transactions obviously would be subject to audit by the controller?
Oh, absolutely, any transaction in the city.
Commissioner Levin and Commissioner Efron.
Wait, so Anita, could you just repeat the answer you gave to Commissioner Deluz's question? You said that all restrictions with a land use, which restrictions come to the Planning Commission?
The removal, firstly, the most clear category that come to us are conditions that are imposed through ULURP, where it is clear that they were land use considerations. And in fact, you know, it is hard for me, because I've not seen records that make clear a distinction in terms of what comes to us. It's hard for me to see any that we had imposed that would not come back to us. Maybe the way they were conceived originally was thought of as a financial consideration or some other consideration, but if in fact it came through our process, then the means of modifying it would really be through us.
Okay.
The second category that I talked about are older and more historical actions that had gone to the Board of Estimate. And in that instance, there is an affirmative effort made to understand where the nature of that restriction originated. Did it originate as just a business term, or did it originate out of some land use consideration that we probably ostensibly were involved in? And so that's the inquiry there.
And just to make it clear, I think all commissioners know this, but prior to 1990, the Board of Estimate approved both business terms and land use
Right.
actions.
So you might not be able to take them apart.
It would be difficult in many cases to tease out what, in some cases at least, to tease out what was a business term and what was land use action, whereas anything post-1990, which is, you know, more than a half a decade, more than 25, a quarter of a century now, anything since 1990, where the council has jurisdiction over land use, it's pretty clear,
Right.
I would think.
Right, okay. Well, it just, you know, it seems to me that with the Horatio Street application that we heard about an hour or so ago, you know, that's a different situation. That is one that was put in place through a ULURP process. And I think the restrictive declaration that's on the books by its own terms says it can only be modified, you know, it lays out the process that would modify it. So it's different than the Rivington case. But it is a perfect illustration of the effectiveness of a community referral in keeping track of what the historic commitments were with respect to any particular piece of property. And it is, you know, sort of fundamental to our land use review considerations that it's local communities that know what's going on the street. And so I would think that for all of these deed restrictions, removing all of these restrictions, there is a beneficial aspect to at least consulting the local community board and the council member and the other elected officials. Just asking them, telling them this is up and asking them for their opinion before any action is taken. Had that happened in the Rivington case, city would still have been free to go do whatever they were going to do. But it would have flagged, and I would argue in that case that that one is a land use, that restriction was put on outside of the kind of formal land use process that you're describing, but limiting it to a healthcare use is fundamentally a land use question. And we don't need, I don't intend in my comments to get into a reexamination of the Rivington case, but I would say, in all of these, what's the harm in asking the locals and getting a referral before the committee that you've described takes action? At least you'll know then what the political landscape is that you're dealing with, and you might pick up some useful information, historical information that you're unaware of. And you might turn up some other users who could take advantage of this publicly created restrictive opportunity.
So to that point, you know, the new process that is proposed doesn't have an explicit referral to a community board as part of the process. It does have some sort of broad statements about the responsibility of DCAS to go out and canvass to ensure that they understand what concerns are, but what you are suggesting is a more explicit and, you know, precise.
Commissioner Efron, then Commissioner Ortiz, then Commissioner Dweck.
I was going to come out on the same issue as Commissioner Levin, but on a slightly different and maybe perhaps more political, small p political way, and that is that it seems to me in the case of Rivington, it was the lack of notification, not just consultation, that seems to have caused the problem, and it doesn't seem as if the notification, in addition to consultation, is contemplated within this, and that probably would have been a responsibility of DCAS under these circumstances anyway. So how does the participation of future city planning commissioners or staff or the chair of the commission ensure that there is that? I mean, presumably that is one of the reasons to have some future person on this committee going forward, so that there would be at least community input,
Yes, and that's
if not a formal way.
Right, that's I think to some degree, what each member of this committee sees its role as and how it fulfills it is going to be informed by the way it operates in its mission. So if you are suggesting that the department consider in fulfilling its role here, that it seek, you know, the view of the community board that would be affected by, that actually is a suggestion that I think certainly would be considered to, as an appropriate way of dealing with this.
And in this process, how formal would that be? Would that be formally considered or stated anywhere, or?
Well, I think one of the things one of the things we should do, if we haven't done it, I suspect we haven't done it, is distribute to all of you. It has been public, but we'll distribute to all of you the proposed the proposed new policy, which, as Anita said, has to go through a CAPA process anyway, and so there'll be much opportunity for public comment. But I can, as I recall, it does call for a more robust public notice and engagement, but we'll distribute the very detailed policy, proposed policy to you all.
No, you're right that it does call for a more robust public engagement, but it doesn't, you know, spearhead, have the community board spearheading that respect, which is what you're talking about.
Ms. Ortiz.
I'd also like to share, you know, my sort of concerns about that piece of it. I guess the way I read the letter was that they were requesting some sort of gold standard of public review, or, you know, the use of gold standard was mentioned. And so my question, and this is sort of what you've asked, and I'd like to reiterate that I'd like to see that, you know, where in the process is there a public and transparent review opportunity? And if there isn't, there should be.
In the proposed process?
Yeah.
Yeah, we'll distribute it to you all. Mr. Dweck.
So, just so I understand it clearly. Our option as a commission is either to waive our right to take this under the Euler process or, and accept the new process, or what is our option? What are we asked to do right now?
Well, what the letter that you received is requesting is that the commission propose to the city council that the commission be given the authority under Euler to consider all deed restrictions. And the way that that provision in the charter is written, it's sort of, a zero-sum proposal. You either ask for Euler.
Or waive it.
Yes, or you don't actually have to do anything. You don't, you don't have to do
We
anything.
take no action, which
Yes.
would
Right.
then allow the administration to continue what they want under
Right.
the new process.
But in addition, you certainly have the right as the commission, separately if you want to, but certainly as the commission, if you think it's appropriate, to comment on the administration's proposal. And if there are aspects of that that you think should be enhanced in order for you to feel comfortable and not feel that there is a need for all of this to go through Euler, you can certainly comment as a
So-
body or individual.
One of the questions I'd like clarity on is, will this new committee be subject to the open meetings rules, or is it just a board meeting?
That remains for, I think, the law department to determine, because as currently conceived, it's a body that actually makes recommendations as opposed to making determinations that are binding. So, that may have some influence on the decision there. But I don't know the answer, and I don't know what the law department has thought in terms of that particular.
But from your perspective as counsel, do you concur with the borough president's letter that we have the authority?
I absolutely concur that that provision resides in the charter. I can't say to you that I am actually 100% confident that it's a lawful provision, because it's a way of modifying the charter outside of the typical charter process. So I would need to think about that a lot before I would tell you that, but it does in fact exist in the charter. I would say though that it really is a provision that exists really for your use. When you identify matters that you think have been completely overlooked in the Euler scheme, that you think there is a critical need for this commission to have purview over. And that in that instance, you ask the council, and if they agree, it becomes part of what you get to look at.
Thank you.
Commissioner Cerullo.
Thank you. Anita, so forgive me if the answer to this question has been already revealed, but I'm not connecting to it. At what point in a process for the removal of a deed restriction would this committee be brought in? So, because, and is there in the process a new starting point to a request for a removal of a deed restriction? Because as we've seen in this, it's conversations take place with an agency, or conversations take place. At what point does that immediately upon the potential for a deed restriction removal, or to facilitate a project which everyone might be in agreement on, never mind the ones where there might be controversy, does that then send it to this group to then make a recommendation? Like what, I mean, maybe it's too far, maybe I'm too in the weeds on this, but is there a new starting point that all requests for deed restrictions, or upon the reality that one may be sought, you shift to a new process that then takes it down the road, so that all these other new players are now involved in it? Because part of the issue, in a generic way, was that, well, there were communications with X, or there were communications with Y, and but no, you know, like, the process just went sort of its own
Why
way.
don't we do this? Why don't we distribute to all of you? This is a very detailed policy proposal, and it is, you know, reasonably dense, and I will say, has many pages, as I recall, having read it. So we'll distribute it to all of you. You can all review it. I think it's, you will see, you may have issues with it or thoughts about it, but I think you will see it as a fairly, it is a very elaborate and detailed process. And ultimately, those deed restrictions that don't come to us currently, and many do, as you know, we see deed restrictions here that were imposed through the EULA process and the land use review process all the time. And frankly, you know, so I suspect most of those, maybe not all, but most of those that have been imposed outside of the land use process or not, that did not come through us, or deed restrictions that predate 1990. So there's there may be some that are post-1990 that didn't come to us for one reason or another, but most of them probably were pre-1990. So it's a fairly limited universe. But having said that, we'll distribute this to all of you. I think many of your questions may be answered, not all of them. You may agree with the process or not. But just to go to the point that Nita was making, that you would think that any change to EULA normally would require the approval of a charter change, and this is a sort of odd provision that gives the Planning Commission the right to recommend to the council a change. All of us who deal with EULA, I think want to be cautious about changes that we make to this process, knowing how complex this process is. Commissioner Dweck.
Just to follow up. So if we take no action and the city implements the new processes, that doesn't preclude this commission or a future commission from then perhaps, if this new process is not working out or determined by a future commission, doesn't preclude them from taking the action that the borough president is requesting? Or are we waiving our right? Is it a use it or lose it right now while they change the new process? And
No, absolutely not.
will the CAPA change?
Take away
our?
Not at all.
Not at all. So it can always be revisited?
Yes.
See how the new process is working and come back in a few years?
Yeah, I mean, the commission can do this sua sponte, basically.
Absolutely,
Right.
at any point it chooses to.
Commissioner Ortiz, and then Commissioner Cantor.
I guess I'm struggling with this because the same reason or rationale that we're using now to avoid the process of going through a revision would apply then too. You know, it would be simply as complicated at any point to go through that process. And yet, we're proposing what you say is a very dense and complicated alternative that sets up a new set of procedures when we have a set of procedures that people understand and are already in place. And so I'm just, you know, trying to understand sort of the rationale behind this alternative.
Right.
Although I completely understand what you're saying, it's very complicated to.
I would say,
Okay, go ahead.
I would just say that when you look at the new policy, what you will see is that it isn't really a wholesale new set of procedures. It really is an enhancement of the process that exists today to address what were identified as sort of the failings or shortcomings of the way in which the Rivington House process was, you know, completed. It's really just providing greater transparency, which is one of the issues, an obligation on the part of DCAS to consult in an active way with other agencies in the city to determine what is the appropriate way to handle this issue that is before it. And it is enshrining a need for a group of city agencies who have a broad perspective to weigh in on the recommendation to the mayor. That's really the most significant new aspect of this, because it's adding a layer of oversight and input that currently does not exist at all. Because heretofore, if it were not a deed restriction removal that came to the commission, we would not be consulted in any respect with respect to whether or not it should be removed. This is adding that to that. But it's not a wholesale creation of a brand new process.
And I just, Anita can correct me if I'm wrong, because I haven't looked at this in a bit, but the proposed new procedures apply to most, not all deed restrictions of various different kinds, a lot of which are not land use items.
Right.
So are really, in many respects, just beyond the expertise or traditional jurisdiction of the Planning Commission, because they are fundamentally business terms which don't come before us. So I think the first thing to do is to look at the process itself, and we will distribute it to all of you. Mr. Cantor.
Thank you. A couple of questions. The chair referenced a few minutes ago that the material, or you referenced, I don't remember which one, that the material comes before the commission and we have the right to participate or non-participate in a decision. Is that, number one, am I right or wrong on that?
That's not correct.
Now, I'm not sure I understand.
The proposed, are you talking about the proposed procedure?
Yes.
Proposed procedure, as Anita said, sets up a committee of the law department, OMB, the first deputy mayor, and city, and economic development and city planning department to look at these deed restrictions, and presumably the reason that the department is looking at them is to see if there are land use implications.
How is that originated? In other words, what's the mechanism, the proposed mechanism for everybody to get notified?
DCAS will be required to notify all of the agencies when there are proposals to modify deed restrictions.
Okay. Next question. You made the point earlier that there seemed to be a conclusion that what happened last time around was due to some sloppy workmanship. Did you not?
I did not make that conclusion. I'm
I'm
not in a position to make that conclusion.
I believe the general counsel was referring to the conclusion of others.
Yes, the controller.
Oh, no, I didn't say it was yours.
Right.
The conclusion was that it was sloppy workmanship, or the word sloppy was used.
There was not adherence to the process in the rigid way there should have been.
And this is a going forward procedure improvement.
Right.
The procedure that was not followed presumably involved a number of people. Do we know, or I certainly don't know, what the disposition is relative to those people? Is that an appropriate question to ask?
I don't think that we are aware of any personnel action being taken with respect to anyone that worked on this street.
Yeah,
That's all I can say.
let me just say, at least I, and I'm pretty sure Anita, and I think everyone in the department knows no more about what happened than any of you do. We've read it in the papers. What I'd suggest is that rather than speculate about what the proposed published new procedures are, we'll distribute it to all of you, and then we will have an opportunity to you all have an opportunity to think about it and look at it in light of what the request is to us. Now, again, the request to us is not a request to, about what specifically we think of the new procedures. The request to us is whether, we should be, as a commission, recommending to the city council that it consider subjecting all deed restrictions to ULURP. And that is a different question to us, but I think the question is a question that should be considered in light of what you see in the new procedures that have been proposed, all of which, as individuals, you're all more than welcome to comment on through the CAPA process. Ms. Levin.
So I think that's an excellent pathway for us to consider this letter. We're not in any formal process with the letter, it's just we've gotten a letter from the borough president and the council member, and at some point after due consideration, we probably owe them an answer.
Exactly.
But what is the timing for the CAPA process? When will the rulemaking?
I don't know, we will.
I'm not even aware that it's actually commenced in CAPA, but I will find out.
Okay.
I will find out.
Okay, so then, Anita, since we have you, I'd be interested in your views. I think I can guess sort of what they are. Should the removal of deed restrictions go through ULURP? And you're shaking your head, so why not?
I can't say as a blanket matter that the removal of all deed restrictions, I believe, should go through ULURP. Because as Carl mentioned, and as I mentioned in my remarks, there are various reasons why certain restrictions are imposed. And to your point, I think.
Well, and most of those restrictions don't even go through ULURP now. They just have to go through a community referral process.
Right. But to your point, in some respect, probably you could argue that any removal of a deed restriction has a land use ramification. Everything does. But
we like to think it does.
But I believe that most appropriately, the commission should consider those things where land use considerations are the primary, focus, and not sort of the ancillary and, subsequent impact of something. So I don't think that it would be appropriate for all of them to come through the commission. And I actually think that for all of them to come through the commission would pose a challenge in terms of how one assessed and looked at them. Because if the primary considerations, for example, are there was a financial transaction that resulted in this, it's very challenging for the commission to assess those sorts of things. And so I think it would be problematic to put the, commission in the position of having to address those things. I think another issue here is the division of responsibilities and what is appropriately executive purview in the context of certain of these. And so I would be concerned about the actual legality of such a sweeping change to vest all of this in the commission when some of those matters really are not appropriately, the commission's concerns. So that's the short of it, and I think the process that we have today, whether or not it works, fully effectively, is appropriate for sort of parsing where certain ones of these need to be addressed and removed. And I think a blanket is an overly broad and problematic way of trying to do it. So
Mr. Dwight.
Just so, maybe perhaps to you, Mr. Chairman, so after we read the proposed rules, are we going to be sending a recommendation as individual commissioners or as a commission, as a consensus document?
Let me make clear, we have no role as a commission in commenting on proposed rule changes in CAPA. So the purpose of distributing what the mayor has proposed, and that will go through a CAPA process, is to assure that you're all well-informed with respect to the matter before the commission, which is responding and assessing the request to the commission from the borough president and council member.
Okay. Thank you.
With that, thank you very much. Thank you, Anita.
So, Commissioners, staff have prepared favorable resolutions for the following. We have the Montefiore large-scale community facility development stair project, which involves an authorization and modification of previously approved large-scale. We have the Dumbo Business Improvement District in Brooklyn. We have 625 West 57th Street, proposed text amendment to facilitate automobile repairs. And I just want to note for the record that Commissioner Zerillo has recused on this item. Due to some internal housekeeping issues, the vote for Autorama will occur on Monday, August 15th at a special meeting. We have, Landmarks Preservation Commission has designated the following buildings as landmarks in Manhattan, including the St. Joseph of the Holy Family Church, St. Paul Roman Catholic Church, the former Firehouse Engine Company, 29, and the 315 Broadway building. We also have a favorable resolution for 38th Street and 31st Avenue rezoning, a zoning map amendment from R5B to R6B to facilitate residential development in Queens. We have the Barnett Avenue rezoning, which involves a series of land use actions, including the mapping of an MIH area to facilitate mixed-use development, including affordable housing. We have the Mitchell-Linden Library proposal, the Rosedale Library proposal in Queens, the NYPD Vehicle Storage Facility, which involves a site selection and acquisition for that facility in Queens. We have the One Court Square office space, which is a Department of Health and Mental Hygiene office space in Queens. We have the 63 Beebe Street authorization, which is proposed to facilitate a pool and a retaining wall in the Special Natural Area District of Staten Island. And Landmarks Preservation Commission has designated 4 Staten Island landmarks involving George William and Anna Curtis House, St. John's Episcopal Church and Rectory, 92 Harrison Street House, and the Princess Bay White House Complex. Staff is not aware of any conflicts with the zoning resolution, projected public improvements, or plans for the area involved for any of the landmarks that have been designated by LPC. And we have a special meeting on Monday, August 15th at 9 a.m. here with respect to La Centrale, which is a series of land use actions to facilitate mixed use, predominantly affordable housing, Community District 1 in the Bronx. And as I mentioned earlier, Autorama report will also be voted out then. Moving on to a couple of weeks from this coming Wednesday, August 24th. The first project is 217 West 29th Street, which is a proposed special permit zoning text amendment and authorization to facilitate retail use and accessory parking. Richard Suarez from the Manhattan office is here. I believe that Richard would like to say something about this project.
Hi. So the commission held a public hearing for the 3 proposed actions on July 27th, and many commissioners did express concern with the height of the resulting ground floor retail space. The applicant's representative did prepare a letter responding to those concerns, which was sent to you over the weekend. And the letter, I'll just kind of quickly run through it, but it reiterates the timeline of the project from the beginning of the pre-certification process to now. It includes some information that wasn't discussed at the public hearing about the need to vest the project under 421A, which was set to expire in June 2015. The letter describes the physical and procedural challenges of removing the second floor slab and also locating a floor area elsewhere in order to accommodate a taller ground floor. The letter presents an argument as to why they propose that the resulting retail space with the proposed height and length will be viable, citing its size and location as well suited for small entrepreneurial establishments. It also notes that there are other retail spaces of similar height and length in the area throughout Manhattan, and notes that the applicant already has a plan for a coffee shop in the ground floor space of the proposed development. The letter also discusses the lobby size that would be facilitated by the proposed actions, which is about 11 feet, as compared to the as-of-right option that would leave the applicant with 4 feet of clear lobby frontage. While the concerns regarding height are fully understood by the applicant, a text amendment is still necessary to address the length of the retail space. The applicant hopes to move forward with the text amendment as proposed, but we want to review these responses and get your thoughts before moving forward.
Any thoughts or questions or comments, Richard? Go ahead, Ms. Levin.
I found the letter quite persuasive.
I think we're thinking about, given that this application got caught up in the transition to ZQA, whether the text amendment can be constrained so that it doesn't necessarily apply on a broader basis. We're looking at that.
Great.
Thank you, Richard. So we also have the Rockaway Beach Boulevard rezoning, which involves a zoning map and text amendment to establish a mandatory inclusionary housing area and to rezone property from R5B C13 to R6A C25. And we have the 86-13 Leverage Boulevard rezoning, special use permit to facilitate an eating and drinking establishment with dancing. We have Brendan Pilar, who's our project manager, for both of these projects to talk to you about this.
Brandon bought a new suit just for this occasion. So impressive.
3 items at 1 review session required a
Very impressive, Brandon.
So we'll start with the rezoning and the Rockaway Beach Hotel, I guess.
Easy.
Everybody's good?
Excellent. And the special permit. Right, so this weekend, the commissioners received correspondence from Queens Community Board 9 in the form of letters the board received in response to a letter that the board sent to neighbors within 400 feet of the proposed project site. All the letters and emails received in response opposed the proposed special permit and the establishment of an eating and drinking establishment with dancing in the cellar of the landmark building, many of which cited concerns and challenges and problems with the applicant's operation of an as-of-right banquet hall, which also provides dancing for private events, as reasons why for their opposition to the proposed special permit. The Department of City Planning's Queens office met with Department Council to discuss what we understood to be the limited options for additional conditions and safeguards that the commission could impose on the special permit. The commission, just to remind you, has to make the finding that the proposed use modifications shall have minimal adverse effects on the conforming uses within the building and in the surrounding area. And due to the information that was received from Community Board 9 and the problems with the operation of the existing banquet hall use that again has dancing in it, we believe that it would be very difficult from a practicality standpoint to really enforce any additional conditions and safeguards on this special permit. Specifically, we looked at modifying the hours of operation, which we believe would be an enforcement nightmare for the Department of Buildings, mainly because it would be difficult to separate the two uses from one another. You already have a use in the building that allows for dancing, and there would be a separate use in the cellar of the building that would also allow for that use. It would be very unclear which use was actually causing the problem of the complainant. We also considered a term of years on the special permit. The commission does have the ability to impose terms of years on special permits. But here too, it would be difficult for the applicant to demonstrate and for the commission to find that any potential complaints that would arise for any use related to the proposed operation on the project site would be for the as-of-right use and not the use facilitated by the special permit. So again, very difficult to separate the two uses from one another. So again, we looked at the two potential use restrictions there, hours of operation and a term limit, and from a practicality standpoint, found them rather impractical conditions and safeguards.
Any questions or comments about this? This was Just my own thought is that I found the letters that the community board sent from neighboring community sort of mixed in a way, because some were really speculative as opposed to what might happen, as opposed to what is happening, although a couple did say that parking was a greater impact than the applicant suggested during the public hearing. And I'm wondering, Brendan, whether you have any thoughts or observations about that.
Well, I understand some of the letters specifically address the parking and noise and just queuing of patrons. I'd only add that the existing as-of-right use, the banquet hall, has the same arrangement that was proposed for the eating and drinking establishment with dancing in the cellular building. There is off-site parking provided today, and based on the feedback from neighbors, it has not adequately addressed the parking issues in the neighborhood. So potentially, the proposed use would only make a difficult situation more challenging.
Ms. Efron, then Mr. Dweck.
I found myself irresponsibly deciding on the operator rather than on the land use. And I am, in retrospect, very worried about the precedent to communities throughout the 5 boroughs about going from an as-of-right use because an operator is doing a good job to going to what seems like an indefinitely risky change in a community, in any residential community, to a nightclub status. I did appreciate Commissioner Cerullo's explanation about what Consumer Affairs does versus what the land use action is, but I just don't find the compelling reason to add a nightclub to a low-scale residential neighborhood, even if the operator is doing a good job with the catering facility.
Mr. Dweck? Any other thoughts to Brendan? Okay, thank you.
Brendan also presented earlier the Queens DA office, and...
That's right, that's 3, okay.
Yes, that's your third. That's your third. And the next item is 141 Willoughby, which involves a series of land use actions, zoning maps, city map, and zoning text amendments to facilitate a mixed-use development, including affordable housing in downtown Brooklyn. We do have a little time on this proposal, so today Alex will recap the concerns identified to date.
So as you recall, there was a public hearing on the 27th. A number of issues were raised and discussed both by the commission as well as through testimony. I just want to reiterate that the applicants are continuing to work on a number of those questions, including a response from the SCA. That is, I know the applicants have met with them or shared documents with them about architectural drawings, and SCA is continuing to review those for both feasibility as well as efficiency. They're also going to get back to us on the cultural component testimony that was brought up as well. I do want to reiterate the DOE commitment for over 3,000 school seats within the 2 school districts. Something that has changed since the public hearing is the Educational Construction Fund has released an RFEI for a school site or multiple school sites 5 blocks from the proposed development site. We expect the applicants to respond in full to all the open questions by the next review session.
Ms. Deluz.
So I just want to make sure on the list of follow-up items, I asked, there's a lot of information that HPD has from Housing Connect about the number of applicants in Community Board 2 and what their AMI levels are. I think that would be helpful as we think about what is the appropriate mapping for MIH here. There's a lot of information.
Scheduling wise, since the next review session is August 22nd, with a vote scheduled for the 24th, perhaps we can, since there's no rush on it, it's got plenty of time on it, perhaps we can push back the vote so we can discuss this with the stakeholders, discuss their responses with the stakeholders. So.
I believe there's enough time.
Okay.
Yeah, thanks.
Any other comments?
And then the final comment was about the precedent-setting nature of the proposal, and just reiterating that this single project is before the full discretion on a site-specific basis for the commission, and that it's a site-specific application.
Okay, thank you, Alex.
Thank you.
And the last item is a CAPA rule change by you as City Planning, City Coastal Commission. So we have Michael here. Michael.
Good afternoon, Commissioners.
A lot of turnout for that hearing.
Yes, precisely. So as you recall, the hearing was on July 27th. There were no speakers at the hearing. We've also received no formal public comments, but I'm here today to hear any comments or questions from the Commission. I'd also like to let the Commission know that DCP staff intends to making a few small edits, mostly clarifications, finer points on the language, not any changes of substance, but happy to hear any questions or comments that you may have.
Any questions to Michael?
Just,
There you go. Vice Chair,
oh, you have the question?
yes, he does. Vice Chairman Knuckles has a question.
Why weren't there any more comments?
Well, I think it's a couple of things. One is that anyone who spent the time to read through it would recognize that they are fairly simple administrative changes that we are making. The other is that I did a fair amount of outreach to the relevant both advocates as well as all the city agencies that would be affected by this in advance of the publication of the rule changes, so that everyone knew what was happening in advance and provide comments in advance of making that
So you
first
weren't
publication.
sufficiently persuasive.
Perhaps not.
Any other
I
questions?
was just going to say that I took the opportunity Friday to put on my Coastal Commission hat and sit by the beach. And the coast is clear from where I was sitting.
Thank you, Commissioner.
All right, seems like clear sailing, Michael.
Puns never end. Thank you.
I believe that is the last item for the agenda.
So is there any other matter to come before this august body today?
Not today.
And hearing none, we are adjourned until Wednesday, and I'll see you all 10 o'clock Wednesday morning. I think all of you Wednesday morning, right? Okay.